Medical Establishment Regulatory Commission to disclose all records
I am
on which
appearing
they had relied upon.
my lord.
Well, they have filed an affidavit. There are substantial documents which they have now disclosed, which were not available to us.
Yes. My
So
lord,
they have filed an affidavit.
in this matter, my lord, Mr. Avik Kartik is leading this matter, my lord. I'm kindly seeking for a day accommodation.
My lord, in that event, my lord, lordship kindly fixes a day when, my lord, the matter is taken up. We'll come and argue out the entire matter, my lord. Any day convenient, your lordship.
My lord, except the 26th, my lord. Except 26. 26.
For the
You come, you do one thing, you come here, take the date, write the date. If you are a choice of the date, let the matter go out of this.
My lord, it's my writ petition. I'll be in some difficulty, my lord. My lord, they are on the other side, my lord. He's appearing for, my lord. I understand, my lord. That's very, most unfortunate, my lord.
The matter.
My lord, we are leaving, my lord. Well,
Call the
My
matter.
lord, lordship keeps it any day convenient to your lordship, my lord.
the 18th, the matter had been adjourned on the earlier occasion for the purpose of effecting substitution of the private respondent complainant.
Yes.
Well, the private respondent complainant had made a complaint to the RERA. On that basis, the RERA had passed certain orders, my lord, which are the subject matter of challenge before your lordship. Now, my lord, the private complainant has died. My lord, we naturally sought substitution, but my lord, it now comes to my lord light that there was a settlement, my lord, entered into after the filing of the writ petition between the private complainant and my lord, the writ petitioner. So, my lord, the private complainant has, my lord, settled all his disputes, withdrawn all the complaints. Now, my lord, only RERA remains. So, my lord, the substitution may not be necessary, and my lord, the wife and heirs have come and said that we have settled the matter, and they have showed us the memorandum of understanding, and said, my lord, though therefore the substitution may not be necessary. If your lordship kindly, my lord, in that case, direct the deletion of, my lord, the private respondent from the array of parties, then, my lord, your lordship may set down the matter for hearing of the writ petition.
I'm appearing for private respondent number 6, your lordship. Bank.
Deletion of private number 6. Deletion of the name of
Deletion of 4, my lord.
4 and 5, my lord.
4
I
and
am
5.
assisting.
4.
Only 4.
Yes, my lord. 4.
Lordship, respondent number 6's name may also be deleted because all the dues have been settled, your
No,
lordship.
that's right, my lord. I don't mind, but my lord, the complainant was 4, and my lord, I will have to now pursue my writ petition against the RERA authority.
What is your prayer in the writ petition?
My lord, my prayer in the writ petition is for setting aside, my lord, certain processes issued by the RERA. My lord, your lordship sees page 76. My lord, to revoke certain orders passed by RERA on, my lord, in 2023, April 27, July 27, etc., etc. And my lord, these orders have been passed, my lord, directing.
Cancel, resign, and revoke the purported order dated 27th of
Yes,
April and July 27.
That's right.
Yes.
Now, my lord, if your lordship sees, my lord, all these orders were passed,
Ah.
of course, by the RERA on an independent appraisal of what they felt was the.
Page?
My lord, these orders, my lord, you will also find. I should show you, lordship, the first of the orders. Lord,
Page 84.
thank you.
Page 84.
84.
Page 84.
Yes, ma'am.
Yes.
My lord, 84, 87, 91, 94. My lord, series of orders.
Hmm.
My lord, where, my lord, the RERA has resumed jurisdiction.
That's why
Well, we-
director to positively appear the next search. A special law officer, director to initiate the proceeding as the respondents for non-registration of the project. You are the private respondent?
My lord, the private respondent is respondent number
No,
4.
in this order, page 89.
Yes, ma'am.
Page
Yes.
89, you are the respondent number 1.
My lord, page, my lord, I am Fabworth, my lord, the first respondent at page 89. My lord, I am, my lord, the company which has, my lord, erected the Marriott Hotel and, my lord, the residences, my lord, which is next to it. Now, my lord, the allegation is that, my lord, I am, my lord, within the jurisdiction of the RERA authorities, my lord, because I have not, my lord, obtained completion certificate. And, my lord, so far as completion certificate is concerned, it has been obtained in 2 parts in respect of the entire building. Well, that is the real case that this is a jurisdictional issue that we have raised. But this apart, the entire basis was that I have not delivered possession of a flat to the private respondent, and on the basis of that complaint, the RERA authority has taken up the matter. Now, that matter with the private respondent is settled. But I do not know whether the RERA authorities really intend to pursue this matter any further, because no purpose will be served in continuing with the hearing and passing strictures or directions against me. Building completed, hotel running, private residences
Not
running.
what you want.
Well, I just want if the RERA authorities come, I can ask them whether they want to pursue these
Who is
orders.
appearing for the RERA? RERA is
Mr. Noyon Chand
respondent number
had
3. Respondent
Yes.
number 3.
Yes.
And you are for the ICICI Bank.
I am for the ICICI Bank, Your Lordship. Respondent number 6.
The ICICI Bank was the financer for the flat which the private respondent
Private
wanted
respondent.
to buy.
So they have settled their dispute with
Yes.
the bank and the private respondent.
Bank,
Yes.
private respondent, promoter, everyone settled their dispute.
So now you are in the.
I only have RERA breathing down my neck. Now if RERA
So
comes,
what is the status of the proceeding before the RERA?
the proceeding, there was a stay order
Stay.
granted. Your lordships are pleased to find that there was prima facie case had been made on and stay the proceeding before the RERA.
So nobody is here.
No, your lordship will fix it, we'll serve a notice on them.
As none appears on behalf of the respondent number 3, who is the necessary party to adjudication of the present application. Accordingly, for the interest of justice, the case is adjourned. Let the matter appear on 11th March.
Yes, ma'am.
11th March under the same heading. The petition is directed to inform the next date of hearing to the respondent number 3. It is made clear that on the next date, if none appears on behalf of the respondent number 3, the matter will be taken up for hearing in the absence of the
Yes, ma'am. Great.
Great.
Since your lordship had passed an order directing substitution, your lordship will kindly record that substitution may not be necessary because the settlement has been entered into with the
Order
private.
was passed. Substitution is passed.
Order of substitution had been passed. Your lordship had given
The
us
council
liberty.
for the
Yes, on the
respondent.
27th of
Take time
January.
to take
2000.
appropriate steps for substitution.
Yes, but that may not be necessary.
Police blended counsel for the petitioner submit that by an order dated 27th of January 2026, this court granted time to the petitioner for taking appropriate steps for substitution of the legal heirs of the respondent number 4. He submitted. In the meantime, we submitted. The petitioner came to know that the respondent number 4 has settled the dispute with the respondent number 6.
6
Yes.
and and the writ petitioner.
And the respondent number 6 and the writ petitioner. And as such, there is no at this stage there is no necessity of the substitution of the respondent number 4.
Grateful, very grateful.
Grateful, Your Lordship.
Next.
I apologize, my lord. I'm assisting senior Mr. Shah. There's an interim order, my lord, that is required to be continued, my lord.
Which one? This one?
Yes, my lord. Item number 18. Lordship had originally interim order granted on the 9th of October 2023, my lord, extended last on the 27th of January 2026 up to the 17th of February.
Grateful, grateful.
Yes.
Interim over
Grateful, my lord.
My lord, item number 19, last occasion they did not file, they were directed to file affidavit in opposition to the main writ petition and to the supplementary affidavit. On last occasion, they did not file, again they have not filed.
Sir, appearing for the private respondent, I'm just putting question of indemnity first, Your Lordship.
But I am for the union. But can you remember this case? But the accused here, the private respondent, but they have cheated money of the present petitioner in Nigeria.
That's the
In Nigeria, that is the allegation. He was arrested, subsequently released on bail in Nigeria. They are saying the warrant of arrest is issued, though it should be enforced to the Indian embassy. But I have got the instruction which says there is no treaty between Nigeria and India. If you should kindly see this,
Yes,
mail. No treaty, there is no obligation so far as deport that person to Nigeria. This is our stand.
This is an erroneous stand. May I submit?
Your Lordship, the fact remains they have made a Interpol a party over, Your Lordship. They have not served, I don't know why. It's an environment over there, and as per the law, Your Lordship, if they have to engage the Interpol, that request has to come from the Nigerian police, Your Lordship, to the Interpol.
You are appearing for whom?
The private respondent.
Hmm.
Now they are putting allegation against me. The FIR copy, I don't know. They have shown some documents, but the authentication is not valid because initially they put allegation against me. That's the fact, Your Lordship. That's a part of the record. I was working under him. I'm not disputing that. But there was nothing such which have been put that have stolen 25%. They are saying it has been stolen for 4 years. After that, they lodge a complaint against me. That's their allegation. They approached the Nigerian police. I was enlarged on bail as them. Then I came back to, because without getting a documents from there, I cannot come over here. And now what they want to enforce here, kindly see the prayer, Your Lordship. That has to enforce from the Nigerian police to the Indian. That's the protocol system. I don't know how this read is maintainable over here. They want the Indian government to assist the Nigerian police. That's the prayer.
Kindly see this mail one.
I will show the law. I will show that my writ is maintainable. Your Lordship, I have come up with the law. And I have backed by case laws also. This is an erroneous submission on part of both of them. On last occasion also, I showed the law to Your Lordship. And my lord, part of the offences have been committed in India. India, part of the offences has been committed in India.
Yes.
So also some law is also on that.
Madam,
that point.
where the case was registered?
I would submit, Your Lord.
Your company was in Nigeria.
Nigeria case was registered.
Just a minute. Your company was in Nigeria. You were working in Nigeria. The private respondent working in your company in Nigeria.
Yes, Your
He
Lord.
has misappropriated or misembezzlement, whatever it has been done at Nigeria.
Yes, Your Lord.
And you have made a complaint at Nigeria.
Yes.
Nigeria authorities have initiated a case against the private respondent.
Yes, Your Lord.
Then the private respondent arrested, whatever it may be done. He was arrested or not?
He was arrested. He was released on bail.
Correct. He was arrested. He was released on bail.
Thereafter, wanted notice.
Whatever it may
He
be. Now
absconded to India.
he absconded from the Nigeria and came back to India.
Calcutta.
Now your prayer is with regard to the direction upon the authority to apprehend this person and to send it to hand
Yes.
over to the Nigeria.
This is not only my prayer. I am in supplementary affidavit. I have made other prayers to transfer to get. There are two parts. One is that part of cause of action arose in India, in Calcutta, because by that money which he defaulted in Nigeria, he has purchased. I have proof. I have come up with the proof.
So you go, if you are having, just a minute, if he has siphon of the money of your company and he brought the said money in India and he has invested the said money in Kolkata, you are having the document. You go and submit all the document to the Nigerian police who is investigating into the matter.
This is not the law.
How the Indian
This
police
is not the law. I will show some case laws. If part of, there are two laws. If my lord, I will go through the statute. I will show the statute. The plenary power with Indian government to try the case in India with the statute section 208 of Bharatiya Nagrik Suraksha Sanhita. Last time I also submitted that section. And apart from this, Extradition Act also favors me and some case laws also favors me that it can be tried in India. I will go one by one through each and everything. And apart from this, if part of cause of action arise in India, there is no need of the sanction of central government even. The case can be registered in India without the sanction of central government even for the part of the offences that are committed in India. The accused cannot be left without any punishment or without any cognizance. My lord, I have got this BNS Act.
Come to the 208.
Section 208.
I don't know how the BNSS will apply here.
My lord, let me submit. There is a plenary statute. Offense committed outside India. Section 208 of Bharatiya Nagrik Suraksha Sanhita.
When the incident was occurred at Nigeria?
It is in 2022, complaint was lodged. Incident happened between 2021, 22, like that. After that, part of cause of action arose in India. In between also that.
How you are telling the cause of action arose in India?
Because he has purchased some properties, I have annexed those proper deed of conveyances in my supplementary affidavit.
So,
That is he has given his mother.
correct. So what is to be done by the Indian police here?
The Indian police need to register FIR against the private respondent
Of the
and his family members
the,
too.
of the incident occurred because your money was misappropriated at Nigeria.
Not money was. I will show your lordship all case laws. Let me submit your lordship.
Whether you are maintaining an account in India, and from the Indian account he has taken out the money and invested in.
Yes, Yes Bank. The report, police report is there that he had an account in Yes Bank which was closed. That has been proved, and other proofs they have to investigate.
Have you made a complaint to the police authority?
Yes, yes,
Where is
your
the
lordship,
complaint?
2 times.
Where is the complaint?
One is in writ and one is in supplementary affidavit. Just on 5th December, I myself went to.
That is not your prayer here. Have you made a prayer for registration of the
Yes,
FIR?
yes,
Where is
your
the
lordship.
prayer?
Supplementary affidavit.
So you go to the other court.
No, not only
There is a
that.
police in action, you go to the other court.
Not only police in action, my lord, Justice Tirthankar Ghosh is released because
of your main prayer.
Because of main prayer.
Yes,
Not only
if you're
that,
telling that
it tried in India. So that jurisdiction, that is within the jurisdiction of your lordship, that your lordship will direct
okay,
central government.
Come,
to-
yes. Yes, submit. What the document?
Yes, your lordship. Your lordship can direct central government to get the case transferred to India. That is my humble submission.
Under which provision the case is to be transferred from foreign country to India?
Yes, criminal case can be.
Show the provision.
Section 208.
Acha. Yes.
Section 208. When an offense is committed outside India by a citizen of India, whether on the high seas or elsewhere, or 208B, by a person not being such citizen, by a citizen of India, first part will lie, whether on the high seas or elsewhere. 208A. The accused is, the private respondent is the citizen of India. And he may be dealt within respect of such offense as if it had been committed at any place within India, at which he may be dealt, though he has committed offense in Nigeria, he may be dealt as if he has committed offense in India. And Indian government has jurisdiction to try him. Even the offense is committed in India. Here, both parties there. Committed in Nigeria, committed in India, in Calcutta. So both parts are there. And even if it is committed only in Nigeria, Indian government can try because of Section 208A, at which he may be found, or where the offense is registered in India. Wherever he may be found in India, it is the choice of the victim to lodge the complaint, and the police has to register an FIR, and he has to arrest him, and central government has to sanction it, and central government has to send a requisition to Nigerian authorities to get the case transferred to India. And my learned friend's submission that there is no treaty between India and Nigeria. I appreciate. This is the fact. There is no treaty between India and Nigeria. But where Nigeria is a Commonwealth country, your lordship, where there is treaty, there is separate law. Where there is no treaty, by way of extradition arrangement between the two countries, culprit can be arrested, he may be tried in India. This is the law. I would show some case laws, if your lordship, that Indian government has tried a person. This is about that case. In a Nigerian citizen committed offense in India, and he fled in Nigeria. Then Indian government, Supreme Court High Court gave him bail. High Court gave him bail. Supreme Court cancelled his bail and asked the Indian government to take appropriate steps. I would show the case law, your lordship. This is exact case of Nigeria. Without sanction of central government, court has cancelled the bail of that accused person. And police officer from Jharkhand made requisition to Nigerian government to please send him to India. This is the case of Supreme Court. Copy. And private respondent has no right to appear. By mistake, I have made a party to him. By mistake. He has no right to appear even. It is a case between government to government. Petitioner and government. By mistake, I have made a party. It was my wrong drafting. He has no right to appear.
Who?
He has no right to appear, private respondent. My lord, may I read the judgment?
Yes, yes.
And I would, section 208 proviso provided that notwithstanding anything in any of the preceding section of this chapter, no such offence shall be inquired into or tried in India except with the previous sanction of the central government. So if central government sanctions, then the offence, even if committed in Nigeria only, then it can be tried in India as if it has been committed in India. Indian government has right, and Indian government should give as permission to try him in India. So this case can be transferred under section 208 of Bharatiya Nagrik Suraksha Sanhita to India. And for that, central government has to issue order to Nigerian authorities, Interpol and Nigerian authorities. And my lord, may I read the judgment now? And Extradition Act also I will show your lordship. This, upon hearing the counsel, the court made the following order. This court had passed inter alia the following order on 4 December 2024. Under these circumstances, we allow the prayer of the petitioner, State of Jharkhand, and set aside the order of the High Court dated 13/5/2022, by which the bail was granted to respondent number 1, Alex David, at the rate of MU Henry, and direct the Union of India to take appropriate measures as they have suggested in their guidelines. The petitioner, State of Jharkhand, shall fully cooperate in this matter so that the respondent number 1 can be brought to India to face the trial pending against him.
Correct. So where the case was pending?
Here, the case offense was committed in Nigeria, and the Indian government has cancelled the bail. So vice versa, this also lies by virtue of section 208 that the case can be transferred. Any criminal case can be transferred to India.
Okay. Pardon.
My lord, may I show other laws for laws that
Time.
may I come at 2 p.m. I will show no sanction even
Counsel for the
part of
petitioner have good talent, but due to paucity of time, hearing could not be completed. Let the matter appear on 11th March.
and not 11th March.
11 March.
He has no right to appear, your lordship.
Lords, may I make a small mention, Lords? May I seek a small indulgence? Lords, today's cause list, item 89. Lords, this is a matter wherein the Revocation Act was challenged, whereby retrospectively all the incentives were cancelled. Lords, your lordships had directed the state to file a reply. No state reply has been filed. WBIDC, that is respondent number 2, they have filed their counter. Now, my only respectful submission is there are other petitions also challenging the same act. Now, I'm only requesting that my matter may be tagged with those matters. One of such matters is listed on 2nd of March before your lordships.
Okay, when the matter will call, you mention that.
Very well, I'm so grateful.
Deeply obliged, your lordship. Let them file affidavit in opposition. Okay, दिए जो slip दिखाइए slip दे दिया मिस अंजू मनोज दिए थे slip मिस अंजू मनोज and Miss Anita Pandey.
Released.
এটা মানে ফাইলটা কিন্তু এখানেই আছে 9th এপ্রিল লিস্টে আসবে
believe the respondent sought time, your lordship directed the matter to
See,
understand, my lord.
I am not against any of the advocates. I am not any. Morning hours, you all advocates
Ask for
making a
listening,
hue and
yes.
cry. This is the urgent matter, urgent matter. I have to spend 1 hour in the evening in the chamber to adjust the list.
Yes, my
And once the court adjusted the list, when the matter is called,
I
my
know.
senior is busy, my respondent is not there, affidavit is not completed.
Respondent sought time,
So
lordship.
why the hue and cry in the morning hours?
I understand, my lord.
And it is not one day, every day.
Every day. And your lordship accommodates all of us, my lord.
And I have to spend one hour in the evening only to settle the cause list.
Yes, my lord.
उसको रख दो, not today कर दो.
Great.
17 not today कर दो.
Great.
Next. Call the fix.
But I beg to appeal, Lord, for the writ petition in this matter.
Yes.
So your lordship.
There are just for point out to your lordship, there are some other matters also relating to the same issue. They are challenging election of the medical council. But there are 3 writ petitions in all.
Medical council.
Lord, today kindly, Lord, today every time, Lord, being bring up this matter, Lord, for hearing, Lord, on some pretext or
You
the
do
other.
one thing. How many matters are
3
there?
matters we have filed. We are interested in moving the 3. Every time we
all
press
3 are there.
Yes. Every time, Lord, we press that 3 applications, Lord, other writ petition has come in.
There is not a point of every time. This is coming after a long time. The last one is my writ petition. All were taken up together.
It about car writ petition.
Matter, identically hard.
Identically hard was.
Analogously hard. That's why that matter should be discussed.
Lord, I have filed, Lord, 3 writ petitions in those writ petitions.
Today the 23306 that is there.
My lord.
When 23380 is there.
My lord.
Then 24183.
No, 23439.
That is not.
Dr. Shukanti Bhattacharya, my lord.
Last one is not.
678.
I am called.
678. Lord, 678.
4183.
What is the 23380? That is there.
That is there.
2330.
23439. 23439.
One is not there.
Lord, I tell your lordship.
So only one is not there.
Yes, I'll tell your lordship in gist. That will, Lord, perhaps assist your lordship, Lord, to understand what is the thing about. Lord, West Bengal Medical Council election, Lord, initially, prior to the election, the first of the writ petition was filed challenging, Lord, the manner in which the election was to be carried out. That is the first writ petition. That is perhaps, Lord, item number 6. During the course of the election, Lord, several other, Lord, frauds were also found out. Complaint was again made, and that's the second writ petition. That is item number 7. So, Lord, that's during the course of election. And after, Lord, the election was concluded, prior to the publication of the result, Lord, there also, Lord, certain irregularities were found out, and those complaints in a comprehensive manner, including the complaints of the previous 2 writ petitions, were also lodged. Lord, that is the third writ petition. That is, Lord, 23439 of 2022.
Correct.
That is, Lord, item number 8.
Correct.
This is, Lord, the long and short of the 3 writ petitions. So, Lord, once your lordship takes
So now what is the 24183?
Lord,
Subsequently filed.
What is your?
Same thing, same issue, Lord. Regarding
well, I don't have any objection.
So what is the affidavits completed in that?
they are filed,
In this also not.
Yes, in this all everything is complete.
their affidavit in opposition in my learned friend writ petition.
Let that proceed in whatever it is to proceed. Why I am today before your lordship, Lord, while moving this application, this writ petition, may I, Lord, conclude?
Can number 3 in my learned friend's writ petition is an application by my client. It is for recalling of an order. Recalling in the sense, Lord, there my consent has been recorded. They have prayed for inspection of all records to be done. First order which was passed, I had objected to that.
Then the learned judge passed an order for inspection. Learned judge recorded that it is without prejudice to my rights and contentions. So, my lord, this issue of inspection I have objected to. Second order, my lord, when they prayed that they will take some time for further inspection is necessary, I objected to that. But unfortunately, my lord, my consent has been recorded in that order. So, my lord,
Which order? Order
Lord,
dated
to that application, we have used an opposition.
Order dated
June 2020.
2025.
2025.
Can 3. Your lordship will take
Can 3 আছে কি?
2 আছে।
না সুকান্তি ভট্টাচার্য একটাই আছে
2-4 কত?
2-4
In which case you file the can? In which? 2-4?
না 23439
2-3-4. The third one.
yes, the last one. Now, my lord, we have used an affidavit in opposition, served them a copy of this on 16th of December.
We have given a reply. Well, they have filed after 2 months.
Look, 16th of December served. Lord, may I file it?
No, yes.
They have not served any reply to us.
I have already affirmed it.
Yes, Mr. Mukherjee, you are appearing for?
I'm for the state government.
Where is the can?
Now, my lord, good, bad, indifferent with respect to this order. Lord, inspection has been completed. Report is there already on record.
File an exception to the report of the special officer.
Report is filed.
Report is filed. Report is filed. Report is filed. Now, my lord, what I want, Lord, why I am today before your lordship is.
This exercise can at all be gone into.
Yes, Lord, that exercise. Lord, that's why.
Lord, that's not the point. But point is, your lordship will see what is the nature of the.
Yes.
They are going to They are examining each and every envelope.
Lord, first and foremost.
This color, that envelope is.
Lord, first and foremost.
This is genuine. Therefore, that. So I do not think that 226 court has that wherewithal to come to a finding as regards that.
Lord, that's.
But I will. Before that, I will have to take an exception to that report of the special officer.
So in which case the report was filed?
Lord, 23439 of 2022.
Affidavit on behalf of the exception, you have filed the exception.
No, Lord, I am relying on that report.
Affidavit on behalf of the petitioners as
Lord, that
exception
is
to
with
the
respect
report.
to the petitioner exception. এই রিপোর্টের এক্সেপশন দিয়েছে জমা রয়েছে
Affidavit on behalf of the petitioners as exception to the report filed by the Manas Chakravarti.
Manas Chakravarti, no, that's a registrar.
That is a registrar. But report is like this 7th August. It's quite a
report.
Lord, and the most important thing is this Manas Chakravarti, who Lord officiated as a registrar, has been found to be incorrectly holding that office and has been removed by this honorable court. So, Lord, the entire election was conducted under his supervision. Kindly considers that.
So subject matter of the main writ petition that has been only been included by a supplementary.
And Lord, my learned senior friend indicates to your lordship that this is not the venture of 226.
I am dealing with the allegations in the petition.
Affidavit filed. Rejoinder to the exception. Who filed the exception? No, ये तो किसका है? ये तो Manas Chakravarti.
Those are all Manas Chakravarti.
Manas Chakravarti का. Who has filed the report? Who has filed the report?
Report Mr. Monish Chandra Roy. Lord, this will be the volume. This will be the volume. Yes. এই যে এরকম লেখা আছে দেখো কম্প্রিহেনসিভ রিপোর্ট এরকম লেখা পাবে। Now, my lord, Justice Moushumi Bhattacharya, while entertaining and admitting this, Lord, না কারণটা তো বলতে হবে।
2022. What is the period of this tenure?
2027 is the next election. 27 is the next election.
5 years.
But that's exactly why I prayed for the urgency.
Your lordship will have to go into, but there are trunks of ballot papers and
prima facie evidence. Prima facie, not even a trial is required. Prima facie evidence. Yes.
So how the writ court can entertain all?
Lord, I shall satisfy that. I shall satisfy that. Lord, this question was urged by Mr. Sen before Justice Bhattacharya. Lord, we argued, and Justice Bhattacharya, being satisfied, passed an interim order to bring all the ballots. And
what was the interim order?
The interim order, Lord, 6th of December 2022 is the interim order.
To preserve the ballot.
Yes, and thereafter the inspection was held. Why to preserve? The reason was this.
Inspection was not.
May I, my lord, just indicate to your lordship?
So how you will prove that that ballot paper?
Nothing is to be proved. If apparently it is evident. Apparently the tampering is evident.
You will have to show to the court.
Yes, from the report I shall show.
To go to court.
From the report I shall show. From the report I shall show.
There are 3-4 pairs.
So you file the exception.
I will have to.
I'm not
filed.
3-4
Leave to file.
Why are they shying away not from facing the court? I do not know.
Okay. Then I will. How soon you will file this? 3 weeks. And when what is the condition? This status of your writ application?
This is
I have filed an office opposition.
I handed over the order sheet to the first order sheet.
No, that's why I am now. You file the reply.
No. He has not filed.
Who?
Not yet.
Mr. Sen. He's telling that he filed.
Yes, today I have given.
Today filed. So you will file the reply.
Lord, last this matter was taken up, Lord, 6 months back. Thereafter, nothing done. Lord, kindly
Okay, you
consider
received.
that.
You will file reply. So
Lord,
you,
3
what I am doing, let me file the exception to the report.
I do not stand in the way. Only, my lord, with respect to the 3 weeks prayer, my lord, kindly consider.
Correct. I am fixing in the month of April. April, 2 dates I will fix so the matter can be heard it out.
Wait.
Correct.
In the meantime, whatever
the pleadings can be completed.
Wait. Okay, my lord.
This
Bow
order
down.
has not listed.
I will record that. The
They want they paying time for filing the
which matter?
This matter-
How many writ petition? Only one. So they have.
Addition of party, other petition. We have
But
filed.
this applicant has filed an application for addition of party in this, my learned friends.
So I will take up all the application together. What is the necessity of the addition?
They want to file evidence. That's why.
Since there is an application.
Once the all be application will be tagged together and be heard together, what is the necessity for adding? Then
Yes, very well. There is an application.
the counsel for you are appearing for Mr. Sen?
I'm medical counsel, my lord.
Learned advocate appearing for the medical counsel. Prays for time to file exception to the comprehensive inspection report. Filed by who has filed this inspection report? Filed by
By the learned special officer.
by the special officer dated 7th August 2025. Full stop. What is the good name, sir? What is your good name? Your good name? So and so, so and so. Submit that. Another writ application being WPA number 24183 is also 183 of 2022 within bracket Dr. Tasbirul Islam and others versus the state of West Bengal and others is also pending before this court connected with these similar issues. Full stop. Full stop. In this said writ application, the medical counsel have filed the affidavit in opposition after serving the copy to learned counsel for the petitioner. Full stop. The petitioner prays for time to file affidavit in reply. Full stop. Consider the submission made by the counsel for the respective parties. The medical counsel is granted leave to file exception to the comprehensive report dated 7th of August 2025 within 3 weeks.
Yes.
Within 3 weeks after serving the copy to learned counsel for the petitioner, you will take exception. What you will take exception?
No, I am relying on that report.
Full stop.
Not only one prayer.
The petitioner in WPA number 24183 of 2022 is granted time to file affidavit in reply within 2 weeks. 2 weeks. Let WPA number 23306, 23380, 23439 of 2022 and 24183 of 2022 be placed before this court on 20 and 21st April 2026 at 2 p.m. for specifics as a specifics matter.
I was led by Mr. Calcutta.
There is one application which is very important.
What application?
Now, can do. Takes it up not once. I'll show you a lot why it's important. There is a problem with the ballot papers. Now, what happens is,
Two four two three.
just give us a second, they will find that out.
4183.
application টা দেয়া জজ সাহেবকে একটু বের করে দাও 23380 can 2 what happens here, my lord? My lord, by the time they take out the papers, just bears with me for a minute. This is not just expeditious. This is an election with respect to the medical council. Now, there is a way, my lord. What happens is these ballot papers are sent by post to doctors all over West Bengal. This is where the problem happens. We have found out from inspection, my lord, from the ballot papers, that what has happened here is you have to tick, my lord, a box of the person you want elected. What they've done is they had in 4 places, my lord, they have tick boxes. So that becomes invalid. Now we want, my lord, what we paid for before your lordship is a forensic audit. Why? To show, my lord, that the ink would be different. And it's been done deliberately so that the people who vote for one particular candidate, their votes will not get cancelled. And we have given the nature of discrepancies, if your lordship sees. And this can only be done, my lord, by a forensic expert. Cannot be done by the High Court at all.
Exception to the report, then this application cannot be heard. Your lordship finds out that whatever report has come from the special officer is to be upheld. Then only this further prayer will happen.
I'll again tell your lordship, the report of the special officer is just records what we have submitted. He has got no, my lord, finding of his own. So what my learned senior friend wants to do is basically to delay it.
Why?
Well, he wants to, my lord, I don't have a problem. He has a right in law. All this while, this is served on them in the year 2023. Till date, it was moved. It was moved before Justice Parthasarathy Chatterjee. His lordship said this will be heard along with the writ petition. Even at that point of time, my lord, my learned senior friend appeared, never prayed for an affidavit.
No, so that's why what I am telling, okay, let this be kept in the record. I have fixed the final hearing 20 and 21st of April. If at the time of hearing, this court find that, then it will be sent, it will be on.
That's what I was thinking. Well,
only the one time. Here your forensic is there. Or
in the meantime, if the forensic happens, then that be the aiding your lordship at the time of hearing of the.
Without any
What happens is, if the forensic is done in the meantime, then again we don't have to get delayed. Suppose your lordship feels that there needs to be a forensic examination. Then on April, your lordship will be giving that order, and it will again go back to say in June, because in May, my lord, there will be a. So that's exactly where, my lord, I'm trying to say, my lord, this is only a piece of evidence which will come up before your lordship. Nothing more than that. They cannot be agreed by that.
It's not a question.
Why are they aggrieved?
You have to make out a case.
I am saying so.
Okay, because now already there is special officer's report is there, and all the things is there.
Special officer's report is nothing on finding, my lord. It's only what objections we have recorded. He was not finding of his own.
So
he's just recorded. No, recorded my.
Then in that case, I am not fixing the matter for hearing. I am fixing the matter of regarding acceptance of report and
within 2 weeks.
Within
2 weeks.
That can only done.
Yes. Kylie fixes it in March, sometimes in March.
Let me file an affidavit. I'll get a chance.
Files an affidavit. He will not take more than 7 days to file. What happens is, by this time, what will happen, the tenure will get over. And the writ petition becomes,
because an earlier application was disposed of on the
May I pray for this,
therefore I did not choose any.
Very well. Let them fight all affidavits. Only, kindly do not keep it in April. Keeps it sometime in March, so that before the vacation, the matter can be disposed of.
But
because they'll not take much time. Not much.
Do it because it's a. Four petitions are there.
Now and only an application.
4 petitions are there. How
only an application, nothing. Kindly. We only want a forensic thing.
No, that's right. If you want forensic, then I am not passing the order. Then let he file the exception within 3 weeks, and for affidavit within 2 weeks. Sarda Corporate they will file, and I am fixing him only hearing of the case.
Yes. Your lordship fixes it sometimes in March.
चारों एक साथ बोला ना क्या बोला इतना डेट नहीं
होली तो 1 तारीख होली खेलবে
है ना?
তো 1 মাস ধরে
शुरू से पढ़ो
আপনি কি এত তাড়াতাড়ি চাইছেন?
रिपोर्ट
ও চাইছে না, আপনি চাইছেন।
এটা কিছু করার নেই জোর চুরি করলে সব
হোক না, আমি এটি করে পারি, এখানে কি আছে?
জোর চুরি করলে জজ সাহেবরা ছেড়ে দেবেন
হোক না।
ठीक 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 है ठीक है आगे
সব বাকি সব স্টেটে তো রিট আসলে কোনো তফাৎই নেই। 226 করে সিভিল রিভিশন চ্যালেঞ্জ
एफिडेविट
আমরা করলেই বিপদ।
हाँ
এখানে বলে এই করো হ্যান্ড করো ত্যান করো এই করো সেই করো সবই
after serving the copy to the land council for the petitioner please for time
ঘড়িটা
for
কিন্তু
reply
তোমার দুর্দান্ত
like full list বাকি কি
তুমি আগের দিনও দেখে বলেছি
the landed council for the petitioner in WPA number 23380 of 2022 submit that the petitioner has filed an application being CAN 2 of 2023 praying for
কি হয়েছে আমাকে
no 2 of 2023
মানে
CAN 2 of
yes
2023 praying for forensic expert report praying for upon praying for appointment
কেন
of
নষ্ট করছিস
appointment of forensic expert
ফার্মাসি
forensic expert for sending which and only one envelope all envelope for appointment of forensic expert ঠিক আছে forensic expert police landed council for the medical council prays for time to file affidavit in opposition let affidavit in opposition in connection with 2 of 2023 be filed within 2 weeks full stop exception to the report be filed within 3 weeks full stop reply to the reply to the affidavit in opposition in CAN number 2 of 2023 filed within a week thereafter. Full stop. Let all the above writ application be placed before this court. Placed before this court 4 weeks, है ना? Placed before this court on 24th of March 2026 for hearing of CAN 2 of 2020. 2 p.m. That's why 2 p.m. April 20. That's not. It's urgent motion under the heading urgent. Yes. So. Exactly. একসাথে করে ভালো হবে otherwise one will go there one will go there all the writ petition be tagged together next
This matter was mentioned by my learned senior on the 12th of February, Your Lordship. He had expressed that he wouldn't be in court today, Your Lordship.
Huh?
He had expressed that he wouldn't be in court today, Your Lordship.
Ah.
Due to some personal difficulties traveling, Your Lordship.
item number
9.
it is specially fixed at 2 p.m.
Lordship, on the 12th, he had mentioned when Your Lordship had
Okay.
indicated that let it be on the list, ask your junior to come and mention
Yes.
again.
When you will be available? April?
Lordship, 19th March, if it's possible, Your Lordship.
Though the matter is specially fixed today at 2 p.m., but the Learned Council for the petition is having some personal difficulties and prays for adjournment. According case is adjourned, let the matter appear. But 2 p.m. you will not get. But let the matter appear on 19th March under the heading urgent motion.
Lordship.
One intelligence other than Monday or Thursday. Other than Monday or Thursday, because on 2 p.m. the court number
Monday is Lord Shiva and Thursday is?
No, sir. Because the court number 28 only takes Monday and Thursday the PM.
Court number?
28
Okay. So Monday and Thursday,
on 2 p.m.
2 p.m. So 20th March, Friday
Lordship. I'm grateful, Your Lordship.
with Lakshmi ji?
Lordship, that would be 2 p.m. Lordship.
No, 2 p.m. No. Urgent motion it will come. It will come as urgent motion.
All right, Your Lordship. I'm grateful, Your Lordship.
20, number 20. Yes, Your Lordship.
Lordship, on earlier auction, the last order was
My lord,
passed by the court.
I am appearing for the petitioner, my lord.
Directed the BL and LRO to
Lord,
verify
the case is relating to the unauthorized construction, my lord. Made on the dark number which is recorded as a pukur, that is pond, my lord, and that is a admitted unauthorized construction detected by the concerned authorities. And
No report is filed.
Yes.
Who has to file the report?
BL and LRO to identify the plot, whether it was a water body or not, and whether it was converted to the
Director to verify the record and ascertain whether the subject land can be classified as a water body or not. Who is for the respondent number 5, 6, and 10? 5, 6, and 10. Report filed? No.
Not yet filed, but if your lordship kindly come at the paragraph number 6 of the order passed by the honorable coordinate bench. The order says that I'm reading, my lord, a complaint relating to the filing of the water bodies was received by the department. Notice under section 53 of the West Bengal Town and Country Planning and Development Act 1979 was issued and FIR was lodged.
Correct.
And on 11th February 2020 before the nodal police station. And if your lordship kindly come at page number 35. Already a proceedings has been initiated by the authority by forwarding the complaint to the concerned authority, that is the respondent number 4.
So what do you want now?
Well, my humble prayer before your lordship is to kindly direct the respondent number 4 to conclude the proceeding, my lord.
Where is the prayer?
If your lordship kindly come at page number.
Servant assistant, one of them is so made. That's number 12 by filling.
Page number 15.
Demolish the unauthorized construction.
And page number, my prayer number A, that
page 35.
Page, my lord, page 13, my prayer, my lord, and prayer number A consisting of the prayer.
Page paragraph 1 is the with regard to the demolition of unnecessary construction.
Yes, and thereafter, my lord, if your lordship
and by taking necessary steps in the written complaint made by the petition being annexed P8. Where is the P8? Please find in a copy of the referred petition with self-explanatory. Where is the petition?
My lord, that is page 35. 35 is the, my lord.
35 is the 35 department technical report.
Technical report. Chief Technical Officer has forwarded the report to the concerned respondent number 4, my lord, in order to take immediate step as per the circular issued by the order of the governor of the West Bengal, my lord. And that circular has been issued pursuant to the judgment passed by the honorable division bench, my lord. And that is why my prayer before your lordship is very innocuous, my lord. Let them conclude the proceedings.
So where is your complaint?
Yes, my lord. My complaint is page.
Your lordship, earlier auction, we have filed a report indicating that the subject land is not under the jurisdiction of.
Pass an order.
Lordship, it is not under our domain. It is under domain of KMC and VLR.
That's the KMC I am directing.
Yes.
That KMC and VLR.
Who is appearing for the KMC?
Was appeared.
Where is the complaint?
Yes, my lord. My complaint is page 33.
33?
Yes, my lord. Page 33. It is the complaint lodged before the municipal commissioner, Kolkata Municipal Corporation, my lord. And thereafter page 34.
33, 34 is your complaint. That's the one complaint only.
Yes.
One is Municipal Corporation, then another is Inspector General.
Director General, Municipal Building Department.
Okay. Then the report is submitted by the technical officer. Wetland Authority to the Municipal Corporation.
Yes, my lord.
To the competent of the conservation body so requested to please inquire into the matter. Then nothing was done.
Nothing was done, my lord.
So this is wanted to dispose of.
Yes, my lord.
The grievance of the petitioner in the present writ application that the petitioner has made a complaint to the municipal commissioner Kolkata Municipal Corporation.
Yes, my lord. Kolkata Municipal
Municipal
Corporation. That is
Corporation.
respondent number 4.
As well as Director General. Which department? Director General? Building Department, Kolkata Municipal Corporation. On the allegation of illegal sanction of building plan and construction over the water body. Full stop. The petition has made its complaint to the concerned authorities on 16th of June 2025. On receipt of the said complaint, the Chief Technical Officer EKWMA. I don't know what is that. EKWMA. By a communication dated 23rd of June 2025, requested the Municipal Commissioner, Kolkata Municipal Corporation, to inquire into the matter and to take necessary action. Full stop. He submitted that in spite of the request made by the Chief Technical Officer EKWMA, the Municipal Corporation has not taken any steps. Until date, the complaint is pending before the authority. Full stop. Counsel for the petitioner submit that the petition will be satisfied if the writ petition is disposed of by directing the
Municipal Commissioner, that is respondent number 4. As per the memo, that is page 36.
Directing the respondent number 4, that is the Municipal Corporation, Commissioner, Kolkata Municipal Corporation, to page number 2, consider the representation made by the petition on 16th of June 2025 and to dispose of the same in accordance with the law after giving an opportunity of hearing to the petitioner. Considering the submission made by the counsel for the petitioner, the writ petition is disposed of by directing the respondent number 4 to consider the representation submitted by the petitioner dated 16/6/2025 after giving an opportunity of hearing to the petitioner and to pass a reasoned and speaking order within a period of 8 weeks from the date of receipt of this order.
Instead of 8 weeks, already direction has been given by these Honorable High Court to submit report, everything that was not submitted by the learned.
That's why disposed of.
As per within 6 weeks,
6
because
weeks for it.
the circular is
6 weeks.
6 weeks.
Next.
Grateful, my lord.
Disposed of, huh? Huh? Ah. What is the matter?
My lord,
Affidavit is required.
My lord,
Affidavit
is complete. My lord, I should not, because in his absence, I do not want to press the application, but the issue.
Okay, not today.
Not today. My lord, affidavit. Oh, okay, then
Not today, not
tomorrow. In his
Next.
absence, I.
Same matter.
Same matter.
21, 22,
Identical
not,
issue.
not today.
21,
Item number 22, I am appearing on with the state.
ঠিক আছে, ওইটা, ওই এক-
Give the name, not today. Next.
May I please, Your Lordship? Your Lordship, this is a petition where my entire bank account, current account has been freezed rather by the HDFC Bank without any intimation.
You want the freeze?
I want the account to be
Defreeze
defreezed so
or
that
you
I can
want-
operate. Yes. From freezing to defreezing.
There's a direction upon me to.
File a report,
Yes, yes.
status report, I believe. A copy আমাদের দিন।
Why you have freeze that account?
Instruction of the police authority, my lord. There is a specific mentioning, my lord. Your lordship, my lord, I am handing over a copy of the deed.
Your Lordship, I have annexed all those documents where the bank intimated me that on the basis of an instruction of a cyber police for fraud case.
You have made a party to the cyber?
Yes. Respond number 5. Now I have inquired from the cyber police as to what is the status, how my account is linked, or what is the nexus with my account with the alleged crime. No reply has been given. Rather, I have downloaded the FIR. A third party has lodged a complaint saying that he has paid certain money to a company by the name of Eros Network. Now he has taken 52 lakhs from that complainant through several bank accounts. Now none of those bank accounts belong to the petitioner. There is no nexus of any money coming from those bank accounts to my petitioner. Not even my name is mentioned in the FIR. So Lordship kindly takes page 89.
My lord, the
Page
communication
89.
which I have received from the police authorities, my lord, more specifically in the page 18 of my report, my lord, the beneficiary account mentioned is of the account of the petition.
No, cannot be because it
That's the-
FIR.
That's the,
Where is that?
my lord, page 18 of my.
We are the enforcement
My lord,
enforcement
17
agency of
it
Karnal,
starts from
Haryana.
17, my lord. Yes, my lord. Page 17, it starts from Page 17, it's an email communication, my lord.
Uh,
Bottom of the page, my lord. We are the law enforcement agency of Karnal, Haryana, India. This is regarding complaint FIR number such and such under section such and such. Thereafter, a table has been provided, my lord. Information required, my lord. In this table, my lord, if your lordship kindly see, my lord, since the table is not the next page, my lord. 5. Top from the 5 from the top, my lord. Extreme right hand corner, my lord, the bank account number mentioned 502.
Empire Logistic.
Yes, my lord.
Empire Logistic.
Yes, my lord.
That one.
My lord, all are the Empire Logistic, my lord. Subsequent beneficiary account is of the petitioner account, my lord.
Which account?
My lord, the 50 2 0 0 596 491.
50.
So it's right, my lord, table, my lord.
50200.
2 0 0 5964 1.
This was the account of the petitioner.
Petitioner, my lord. My lord, thereafter, my lord, information required. Subsequent in the bottom, my lord.
Correct.
In number 6, my lord, please freeze the debit and block the beneficiary account, my lord.
Correct.
My lord, accordingly, I have acted in accordance with the instruction which I have received, my lord. And my lord, the allegation that bank has not intimated, my lord, I have intimated. I have acted upon this information.
Oh, then 7, there is another. Refund the money into the sender accounts as soon as
possible. My lord, since it is an OD account, my lord, so I cannot, my lord, do that. But my lord, I have
You have freeze the account, but you have not sent the money to the
my
police.
My lord, my lord, the allegation is that bank has not provided any information. That is also wrong, my lord. Immediate after doing this, my lord, I have
So now whether you ask for the bank from the police, what further action has been taken?
I cannot, my lord, because the notice under.
What is the allegation against?
My lord,
Because you are one of the beneficiary of the embezzlement amount. Kindly see the page 18.
He said that it has been transferred to this account.
Correct.
Yes.
So you are one of the beneficiaries, some amount you have received.
Check up with my client and come back.
So now what I am doing, so you check it. I will direct, again you send the notice to the respondent number 4, SHO.
5.
Respondent number 4 is 5. Respondent number 5. SHO officer, cybercrime police station, Karnal. You send the notice and I specific if you will not submit the report by the next date and I will pass appropriate.
In the meantime, let me check up.
You also check in the meantime.
Let me check up how much money is involved. I can execute a bond. This I will on the next.
Because the later judgment you also check the division bench of the Bombay High Court.
Yes.
There is a specific direction that has been upheld by the Honorable Supreme Court. Unless and until the investigating agency will not obtain the report, the order from the court under section 107 and 108 of the BNS, so they cannot freeze the account. Check that.
Should that judgment?
My lord, may I ask if this is an OD account of the petitioner?
Maybe.
There is an overdraft, my lord. We have not.
I will see. The petitioner has filed the present application, praying for the direction upon the respondent bank to defreeze the current account of the petitioner. The bank has submitted the report and submit that the bank has freezed the account of the petitioner on the instruction received from the SHO Cybercrime Police Station, Karnal. As per the request made by the Cyber Police Station of Karnal, it is mentioned that the account of the petitioner, the petitioner's account is also one of the beneficiary of the one of the beneficiary of the fund, which of the fund involved in the FIR registered by the police of PS Karnal. Police. The petitioner has filed the affidavit of service showing the service of notice upon the respondent number 5, but none appears on behalf of the respondent number 5. Accordingly, this court is of the view one further opportunity is to be given to the respondent number 5 to bring in before passing any further order. Accordingly, petition directed to serve a further notice upon the respondent number 5 informing the next date of hearing of this case It is made clear that in spite of receipt of the notice, if the respondent number 5 failed to appear before this court or to file the report, this court will file appropriate, will dispose of the writ application as per the materials available on record. The petition directed to file the affidavit of service showing the service of notice upon the respondent number 5 on the next date fix. Next, let the matter appear. Almost within 1 week you complete.
1 week.
Let the matter appear on 2nd March.
Second one.
Second month.
Guys,
Second
holiday.
6th March.
Grateful.
Under the same heading.
The Reserve Bank has come now.
No,
Again person.
If you don't get the one, RBI 25 months, I have been told the petition.
If I appear on behalf of the respondents number 2 and 3.
Petitioners are a principal and faculty members of a college, my lord.
I'm like them to Shami Mamadi, arguing for number 24.
I do not have any grievance against them, my lord. I think they are for the college. My entire grievance is against the registrar of the respondent number 1, my lord.
Respondent Registrar of Societies.
Registrar of Society.
WBIDCC. Yes, what?
There are huge financial irregularities in the college, my lord. I am the principal and other faculty members, my lord. This college is run by a management, my lord, which is registered under West Bengal Society Registration Act, my lord. All the faculties are not getting their salary for more than 34 months, my lord. Area salary is not clear, my lord. Provident fund is not deposited. Infrastructure is not there in the college, my lord. No.
Who is appearing?
But if the college is my learned friend, I'm on behalf of the university, and the university lordship kindly comes to page 55. We have in fact stopped the affiliation for this particular academic year on account of the various irregularities in the college.
Who is for the, you are appearing? Yes.
See, for the college, my lord, respondent number 1.
Who is the one?
Registrar of Society, my lord, respondent number 1.
He has asked for a.
Their presence is very, very required.
No, I want the report is to be filed. Compliance of the order, the matter be placed before the honorable court.
My affidavit of service is there.
They have the presentation before the registrar of society. They are the main.
So who is appearing for the Registrar of Societies?
Serve, my lord, nobody. My only prayer is, my lord, to appoint a special officer, my lord.
No, unless and until a report is not. So I am directing you issue fresh notice, and I will specify on that day they will not come, then I will appoint you. The petitioner has filed the affidavit of service. Let the same be kept with the record. In spite of service of police of so and so, you are appearing for the respondent number
5 and 6.
5 and 6, and so and so appearing for
2 and 3.
2 and 3, and so and so 5 and 6. None appears on behalf of the respondent number 1. Full stop. This court finds that the respondent number 1 is the this court finds that the respondent number 1 is the this court finds that in spite of service of notice, respondent number 1 is not appearing, and his presence is very much required for a proper adjudication of the present writ application. Accordingly, the petition is directed to serve a fresh notice upon the respondent number 1, intimating the next date of hearing, and to file the affidavit of service on the next date fixed. It is made clear that in spite of service of notice, if the respondent number 1 failed to appear before this court, the writ application will be taken up for hearing in the absence of the respondent number 1. This is the matter on 10th of March 2026.
I am happy on behalf of the opposite party.
Your Lordship, Advocate Juhi Datta Chakraborty is for the petition. Your Lordship, Advocate Juhi Datta Chakraborty is for the petitioner. Due to the demise of her mother-in-law, she is unable to come to the court, Your Lordship. Therefore, I am praying for a week accommodation, Your Lordship. Kindly, Your Lordship.
As
per the prayer made by the counsel for the petitioner, case is adjourned. Let the matter appear on 17th March.
17th March.
Next.
Lordship, this is the matter of a custody of a minor child, Your Lordship.
What can be done?
Peculiar, is peculiar. This is where they have filed a wrong determination. First of all, Lordship, that is
They have asked for the prayer representation for their prayer is of page number 22. They have annexed the representation.
Lordship, I shall come up.
I'm ready on that day.
Lordship, Lordship.
He has no income. His statement of facts are good, but he has custody of child.
So go to
What is the
the
income?
go to the section 12, guardianship.
Yes, that is a nature, and only 3 months, 3 years.
Guardianship is pending.
From the pleadings, it shows they have filed application.
Section 7, file the section 7, file an application 12, interim relief. Go.
Lordship, I shall come back, Your Lordship.
Come
Great.
back, no, you go to the district judge.
Only 3 years already. He has no income. He said
Okay,
that. I have
okay.
no income. So how the custody of child is maintained?
Okay, Kal, next.
Grateful, Your Lordship.
27 Lordship, I am
17th March. 3 March.
This is my entry for that. Also, in this matter, Lordship, the private respondent is sinking water by installing submersible pump without getting any permit from the authority concerned. The petition Lordship made a representation before the concerned authority for stopping.
Who are you?
I am the just beside the landowner.
You are residing?
Just beside the
landowner.
Landowner of the submersible pump. I have also submersible pump. I have a license. I have permit. Kindly see the page number 18, Lordship.
Page number 18.
Only Lordship.
I cannot read this. What is written in this page number 18?
Lordship.
Yes, what do you stated?
Lordship, only stated Lordship in this area, only stopping sinking water. That is the Lordship allegation in this complaint, Lordship.
Therefore, only considered.
Only considered, Lordship, page number 18.
Private respondent is sinking water by installing the
submersible pump without
getting any permit. Sinking water. The main grievance of the petitioner in the present writ application that the private respondent by installing submersible pump without getting any permit from the competent authority is sinking water is sinking the water, groundwater. Full stop. The petitioner has made complaint to the concerned authorities, but the authorities failed to take any action on the complaint made by the petitioner. Counsel for the petitioner submit that the petitioner will be satisfied if the direction is given to the authority. Who is the authority?
Lordship, respondent number 3. The geologist.
So that is the respondent number 2.
3, Lordship.
3. Respondent number 3. To consider the representation submitted by the petitioner and to dispose of the same in accordance with law. At the learned counsel for the parties, this court find that the petitioner has already made a complaint to the respondent number. Complaint was made to the 3. To the respondent number 3, and the complaint is still pending before the respondent number 3. Accordingly, respondent number 3 is directed to consider the representation submitted by the petitioner and to dispose of the same after giving an opportunity to hearing to the petitioner within a period of 6 weeks after receipt of the within 6 weeks from the date of receipt of this order. WPA disposed of. Next.
Your Lordship, in this matter, I am appearing on behalf of the petitioner. I am led by Mr. Rishabh Kanani. I'll just start in the meantime. He's approaching the court, Your Lordship.
You are appearing for, madam?
I'm appearing on behalf of the petitioner, Your Lordship.
What is the prayer?
Your Lordship, I am only seeking that I have applied for the rectification in my Aadhaar card on the date of birth, Your Lordship. Year of the birth specifically, where it was
year of the birth.
Yes, Your Lordship. It was incorrectly mentioned as 88 instead of 84, 1984. So I have, Your Lordship, I have applied for the rectification on October 3rd, 2024. But still, till date, the concerned authority has not yet rectified this. My only prayer is directing the...
Where is the birth certificate?
Your Lordship.
Birth proof. You can ask for the correction of the birth, but where is the birth proof?
Your Lordship, I do have it. I'll just I have the Aadhaar card in the rectified also.
Aadhaar card you are having, you have filed a form for rectification of the year of your date of birth, year of the date of birth.
Yes,
So
yes.
now that has to be rectified with connected with the corroborated evidence. Where is
Your Lordship, it so happened that the correct year of birth was also mentioned, but this is the third time rectification. In the first time, it was 84 only, but thereafter, after the second rectification was the error in the spelling of my father's name. During that time, what the agent did was somehow he inadvertently mentioned the wrong.
Where is your data? Where is your Aadhaar card?
Your Lordship, I'll just produce this thing.
You're not also not enclose the Aadhaar card.
Yes, Your Lordship, I deeply apologize for this. Your Lordship, I'll just hand it over to Mr. Kannani.
Lord, 7:59 to here is quite a run.
So you persons are not going to the morning work. So this is the.
We anyway, I cannot will not comment.
Your Lordship, if you could grant me a 10 minutes passover, I'll just produce the Aadhaar card, Your Lordship.
Ms. Datta, I'm here. I think you cannot hear me. My lord, this is simpliciter application for rectification. My lord, date of birth of the petitioner initially was correctly recorded. Thereafter, there was a change. There was a rectification of father's name that the petitioner applied for. That got rectified. Along with it got rectified the date of birth. My lord, now the second application for reimposing.
Where is
yes,
the Aadhaar card?
My lord, when the brief was given, my lord, the Aadhaar card has not been annexed. We have it with us, my lord. Your lordship can keep it tomorrow, any other day. But my lord, there's another thing, my lord. Your lordship need not get into it. Because my lord, your lordship sitting here will not decide whether my rectification should be allowed. My lord, the application was made long back.
No, that's correct.
They have not considered it.
No,
Kindly
that's correct. That's
let them.
The Aadhaar card is to.
Yes, my lord.
Yes, by
my lord,
supplementary affidavit.
Yes, my lord. My junior is there. Kindly keeps it any day next week. We'll file a supplementary affidavit, my lord, and come back.
The counsel for the petitioner prays for leave to file supplementary affidavit by disclosing the Aadhaar card in which the petitioner intend to rectify the date of year of birth. Year of birth. Accordingly, prayer is allowed. Let the supplementary affidavit file within a week.
Yes.
Please the matter on 10th March.
Deeply. My lord, I have the. My lord, I'll file a should I hand it over? Like I have the
file supplementary file.
Yes, my lord. It'll be correct.
That will
file and stuff.
Next.
Deeply obliged.
Much obliged, Your Lordship.
Your Lordship, item number 29, 30, 32, 33, 37, and 39, all are analogous matters, Your Lordship. And we have served the copies to the respondent except government pleaded, Your Lordship. We are paying 1 week's time to serve the copy to the government pleaded, Your Lordship.
What is a prayer? Return back all the documents in origin.
My lord, all documents are kept with the authorities, Your Lordship.
Who are you?
We are petitioners, Your Lordship.
No, you are the petitioners. Who are you? Who has to give the document back to you?
So government.
You are the students.
Your Lordship, command hospitals.
Government hospital.
Command hospital, Your Lordship. So we have prayed for, we have filed this writ petition. Your
How
Lordship.
the original document when you obtain the service?
No, Your Lordship, at the time of admission, they have taken all the documents and they committed that.
College.
Your Lordship.
So you have completed your medical this MBBS course.
My lord.
But there is a bond. There will be a bond
But my lord,
to serve on
my lord, we are going to satisfy every point, Your Lordship. Just paying 1 week's time to serve the copy to the government.
At the time of admission, the students has to execute the bond after completion of the MBBS. Then you have to serve the state for 2 years.
My lord,
I think
my lord, that
don't know whether it
no,
is
Your Lordship, correctly. This is applicable for the state.
one.
just to bring one much time to serve the copy to the government printed orders still.
Item number?
Item number 29, 30, 32,
30, 31.
30, no, sorry, Your Lordship, 32, 33.
No, 29, 30.
32,
32,
33,
33,
37, and 39.
37,
and 39.
and 39.
Your Lordship.
The learned counsel for the petitioner prays for time to serve the copy to the respondents. Let the audit application along with the document is served upon the respondents within a week from date. List the matter on 12th of March 2025. On the date fixed, the petition directed to file affidavit to service.
Deeply grateful, Lords.
Yes, next. Call 31.
My lord, this is my petition.
उनको बोल दो एक साथ बांध देने के लिए. All be tagged together.
My lord, this is my petition, my lord. My lord, I'm filing the
31.
affidavit of service.
31.
Yes, my lord. My lord, in this matter, the petitioner is a retail business owner, my lord. And petitioner got informed that his PAN card has been declined while entering the PAN card on a website. The petitioner was informed that his PAN card was declined initially. Later on, he bank, the US Bank, Dalhousie branch, and he was informed that he got freezed. And inspection, he was informed that a complaint has been made, a cybercrime complaint, in the cybercrime police station of Pune, Maharashtra, and dated on the 30th May of 2024. And pursuant to that, his account got freeze. And what happened in this matter is he was being paid by a certain person named Vikram Boshak. And since he runs a retail business of garments, he was Vikram Boshak was a customer of this petitioner. So he paid directly to his bank account, and by virtue of that, his bank account got freeze. He is not a complicit party in this alleged crime, and no direct FIR has been made.
What is your prayer?
My prayer is for the defreezing of the account as well as for the defreezing of the PAN card, since it is my business account. Maybe like a lien can be imposed on the said amount, that is the disputed amount.
What is the disputed amount?
The disputed amount is of rupees 81,000, my lord. Kindly come to page number annexure P4, page number 31.
Milord, I am appearing for the Yes Bank Limited, Milord. Respondent number 4 and 5. May I be allowed to appear virtually, Milord? Milord, pursuant to the complaint made by the complainant before the cyber police station in Pune, an FIR was registered in 2024, Milord, on 24th July. And thereafter, a notice under section 94 of the BNSS has been served upon us. By that notice, there was a direction upon us to debit freeze the bank account till further instruction and to mark lien with respect of the disputed amount, which is rupees 81,000. So we have complied in respect of the notice which we have received from the cyber police station Pune, Maharashtra, my lord.
My lord, may I submit, my lord? My lord, as per my instruction, my lord, it is a layer 2 transaction, and the victim has transferred the amount to the.
Who is the victim?
The victim is a person named Dastu. He's a person named Dara.
He's a party here?
Yes, he is a party. He is respondent number 12, my lord.
Dara Tarmus.
Yes, Dara Timurus Pestonji. And my lord, kindly come to P4, annexure P4, my lord, 31 page number. My lord, here you would see in account.
Okay, that's why. But
yes,
serve the notice.
And my lord, that disputed amount is of 81,000, but my entire bank account has been freeze, my lord.
So this all are your bank account?
Yes, this is my bank account. That is
page 31.
Which 31?
The first one is yours.
The first one, yes, my lord. Shivashi Zor is mentioned in the remarks portion. That is the petitioner.
This is yours.
Yes.
That is only one.
Yes.
So you do one thing. You serve the notice to the investigating agency.
Yes, my lord.
But they have not appeared.
Yes,
not
my
appearing.
Lord. Yes.
So I am directing you serve again a notice informing the date.
Okay.
Correct.
Yes,
and file the affidavit service on the next date if they will you are appearing. If they will not appear on behalf of anybody will not appear on behalf of the 10 and 11, then the order will be.
And I am appearing for respondent number 1 and 14.
1 and 14.
1 and 13.
13. Officer in charge. That is the police, local. The grievance of the petition in the present date application that the bank has freeze the account of the petitioner as well as the Aadhaar card
No, PAN card.
as well as the PAN card, due to which the petitioner is not in a position to operate the bank account. Accordingly, police staff, when the petitioner has inquired from the bank, it was found that the bank has freezed the account of the petitioner on the communication received from the respondent number.
Respondent number 12, my lord. The private respondent.
No, the private respondent is the complainant. Police authorities
Police is coming under respondent number 8 to 10, my lord.
of the respondent number 8 to 10. Full stop. The petition has served the notice to all the respondents, file affidavit of service, but none appears on behalf of the respondent number 8 to 10. 8 to 11.
8 to 11, my lord.
10, 11, put on. 8 to 11. Accordingly, this could direct the petitioner to again serve the notice to the respondents number 8 to 11 by informing the next date of hearing of the present date application and to file the affidavit of service on the next date fix. It is made clear that on the next date fix, if none appears on behalf of the respondent number 8 to 11, the matter will be, the writ petition will be taken up for hearing in the absence of the respondent number 8 to 11. List the matter on 13th March.
Grateful.
Grateful, my lord.
Yes. Original side.
Whereas before your lordship calls on the original side matters, item 111, my interim order is expiring today. I have served notice on the other side as well. Whereas will kindly see this is the last order your lordship passed.
Item number?
Item number 111.
Record an order, please.
Yes.
What is the matter?
Well, is the declaration of fraud by the bank, your lordship recalls, addendum not served. Addendum not served, my lords, in my account.
Lordship will kindly keep those matters in the same matters.
Have you served this forensic audit or?
Satisfy your lords. 95 is pending before NCM.
That
Okay. Though the matter is listed as item number 111 of the today's list, but due to paucity of time, the matter could not be taken up for hearing. According to counsel for the counsel for the petition has mentioned the matter and prayed for extension of interim order. Learned counsel for the respondent bank raised objection for extension of interim order and submit that due to the interim order, the bank is suffering badly. At the learned counsel for the respective parties, this court finds that the petition already enjoying the interim order since then, since long time. Accordingly, the interim order extended till 20th March 2026 or until further order, whichever is earlier. Let the matter appear on 18th of March 2026 under the heading urgent motion.
I'm grateful.
Urgent motion, that will be taken.
Grateful, my lord.
Next.
My lord, may I plead for item number 34 and 35, my lord? I am appearing for the petitioner. My lord, in this matter, my lord, Mr. Joydeep Kaur is leading me. My lord, probably this matter will appear tomorrow in the beginning of the list only. My lord, Mr. Kaur is not available till 23rd. My lord, may I pray that these matters be listed after 23rd, my lord?
34, 35?
34, 35, my lord.
Got an order. 34, 35. Learned counsel for the petitioner prays for time. Accordingly, case adjourned. Let the matter appear on 17th March.
My lord will not kindly, my lord keeps it on 17th March. My lord, there is a little bit of urgency, my lord, in this matter. My lord will kindly keeps it next week, my lord, any day fixed.
It is not possible, madam.
My lord, then let it appear, my lord, on the list in 23rd or 24th, my lord.
It is 27th.
24th, my lord.
27 March and 27 February.
27th March, 27th February. Grateful, man.
Yes.
Lordship, with your kind leave, may I be permitted to mention a matter?
Original side?
Yes, Lordship.
Just a minute.
Lordship, item number 113 of my lord's list. I'm mentioning upon notice, Lordship.
I appear for the respondents in this matter.
Lordship, this matter. Lordship,
Item number?
113 of my lord's list, Lordship. Lordship, this is regarding a tender matter, Lordship. Matter is running in the list, Lordship, but it's not getting a chance to be heard, and we are apprehending that the tender will be given effect to. And once it's given effect to, my writ petition becomes infructuous and my rights will be prejudiced, my lord. I was humbly praying if the matter could be fixed on any date for hearing. Otherwise, we'll not.
Suggest the date.
I understand my lord's list is very heavy. Yes, but once the land is already allotted, as per the tender to someone else, we are challenging the process, and it is a short matter, Lordship. It will not take too much of my lord's time. I understand my lord's list is full, but if some accommodation can.
Lordship can fix the matter for hearing, Lordship. Mr. Ford is reading.
कब होएगा कुछ आएगा? March 345.
27th February at
February
345. I am so grateful, my lord.
देख दो note कर लो.
At 345. I am so grateful, my lord.
27th February to 345.
Oh, Lordship, 27th February is a Friday, Lordship. 345.
You want urgent matter?
Lordship, I am.
That is a slot lying vacant here.
Lordship, I am grateful to my learned friend who has. Lordship, any other day. Lordship,
urgency.
After a very grave prayer of mine, my lord has allowed it, but it will become infructuous if the matter is not taken up, my lord.
Tell your bar not to take the resolution.
Lordship, I am too small of a member to be effective.
There is an observation that all actions will abide by the result of proceeding. Therefore, my learned
Lordship, 20, not on a Friday, Lordship. 345 any other day. 345.
Long allotment has been given.
Then 12th March will go.
I am okay with that, Lordship.
345.
12th March 345.
I am grateful, my lord.
Please, my lords, may I mention item 99 of my lord's list? My lord, my interim order is expiring next Thursday.
When?
My lordship, next Thursday.
Thursday means what is the date?
26th February, my lord.
26, 25 correct.
Please, my lord.
To be mentioned for extension of interim order. Yes. Call. Yes. What is the date of the judgment? Why you are sleeping? Yes.
Item 1.
Please, sir. Kindly have the last.
Yes, paid the amount.
Yes, Lord will recall, Lord, 5 crores I had to pay, Lord, in total, out of which 1 crore had been paid. 1 crore more was paid, Lord, and it was agreed via the email dated 9th of February, my lord, that I will pay 3.5 crores on or before today, my lord, and they will give a NOC, my lord.
NOC?
Kindly seize the email.
Yes.
Whether I had agreed that by today they will pay or not. Kindly seize. I'm carrying the email. Kindly seize whether I have anywhere said that before today. Today we are on the 18th.
I am handing over the checks, my lord.
Kindly seize the email at the top. 9th of February email. We said that in next 4 days. So today we did not agree upon.
So 18th February, by which I will make the payment of 4.5 crore.
We are on 18th February, my lord. The checks are here, handed over, my lord. They will be cleared. My client has spoken to them yesterday also, to Mr. Kanodia, if I'm not wrong, he is here. And he assured that if the checks will be handed over, he will not press upon it, Lord. The complete, I am handing over the complete amount, Lord. The checks will be cleared.
Okay, you do one thing.
Checks are dated, my lord, today. All today.
Okay, you do one thing. You deposit your check. I am fixing next week. If it is then it will be
Very well.
disposed of.
Very well.
Overdue interest as on date is 77 lakhs.
Lord,
As per the order.
Lord,
I'm forgetting about the suit. The decrease of the claim is of 13.5 crores. Forgetting everything.
So including this amount, out what is the total amount?
77 lakhs 22,754 as on date.
Lord, only one minute.
Only interest as per the affidavit.
I'll not go ahead, my lord. Lord, this email says that if I pay 4.5 CR, that will be full and final amount. I am paying for 4.5 as full and final, my lord. Now, my lord, change.
Okay, you have paid the check. I am fixing next week.
Very
Let you in cash, then we'll see to that.
Very well.
The alleged contemner has handed over 4 checks.
3 checks.
3 checks of which bank?
Lord,
Give.
I will give the copy.
But only one other thing. The alleged contemner is not the person who is handing up the check. That is somebody else. Kindly record. Yes, no,
handed over
just
3
recording.
checks
I'm
of
just saying, please
IDI
record that,
Bank.
nothing else.
Checks had to be made by Mark AB.
Nothing.
IDI Bank
Just record. Nothing
dated
else.
18th of February 2026. In the name of the petitioner, is try overseas. Petitioner,
Yes.
in the name of the petitioner, of which one check amount having check number 157964 rupees 1 crore, comma,
is unbelievable. The
second check having check number 757962, an amount of rupees 1 crore 75 lakhs. 1 crore 75 lakhs. And third check having number 757963, amount of rupees 75 lakhs. Total amounting to rupees
3.5 crores.
this one.
Yes.
Three checks are
These
3.5.
and they have paid 1 crore
3.5.
yesterday. 1 crore they have paid yesterday by bank transfer.
It is submitted by the petitioner that the alleged contemner also paid an amount of rupees 1
crore.
1.1.
No, 1 crore. 1 crore.
1 crore on
17 February
17 February 2026. Full stop. The counsel for the petitioner further submit that though the contemner has handed over, the learned counsel appearing for the contemner has handed over the said checks, but the said checks are not issued by the alleged contemner. Full stop. Counsel for the
Lord, it
petitioner.
has already come in the order that the sale proceeds will be directly paid by Mark AB.
Okay.
Yes, I'm not joining it.
The learned advocate appearing for the alleged contemner submit that the check has been issued on behalf of the alleged contemner. Check has been issued by
Mark AB.
Mark AB.
Your lordship will find from the check.
Issued by
Mark AB Capital Private Limited.
Mark AB Capital Capital Investment Limited India Private Limited. ठीक है? Full stop. Let the matter appear. The copy of the check be kept with the record. Full stop. Let the matter appear on 27th February. 26th February.
Lord, only one humble request. But only these checks are going to be cleared. I'm sure on that. Lord, his appearance, Lord, may kindly be exempted. If the checks get cleared, if it doesn't get, Lord, he'll be here. Lord,
It is made clear that if the check is cleared, comma, the alleged contemner number 4. Content number 4 is not required to appear in person. If the check is dishonored, comma, the alleged contemner is required to appear before this court in person on the date fixed.
But could it retain its position on the 26th?
Under the same heading.
To be mentioned. Great.
Lordship, I appear for 5, 6, 7, and 8. Contemner number 5, 6, 7, and 8.
Finally, it seems your lordship is going to get relieved of this matter.
Let us
finally, let's hope. Grateful.
Hope for the best.
For the best.
Yes. Evidence.
But I understand, my lord, they have written a, they have
Yes,
given a
yesterday
request.
they have made a prayer.
But any short date, because I am on the verge of concluding, my lord, only.
As per the prayer made by the counsel for the defendant, though the matter is specially fixed today for cross-examination of the defendant's witness,
Yes.
Cross-examination of defendant witness, but counsel for the defendant prays for time, according case is adjourned. Let the matter appear. Yeah, short date. In
Sir,
none of
this
the
is
court
the
I have get.
chance, this is the chance, my lord, they are taking, because my lordship recalls my judgment upon admission failed. I want to, my lord, get it. They are not utilizing the property, not paying, and just, my lord, playing.
इससे पहले कोई नहीं 30th March 3:45. 3:45. Yes, next.
My lord, my name is Dr. Dipankar Chakraborty. I'm a doctor by profession. I have filed a writ petition against the Indian Bank as well as DRT.
Have you served the copy? Have you served the copy to the Indian Bank?
There is the problem, my lord. I have served the copy to them, and that has come back that there is no branch there. They have given that address, and that is being registered.
Bank?
Pardon? Indian Bank, my lord. And they have registered that address in DRT also.
You have sent the now you have sent to Indian Bank or Allahabad Bank?
Indian Bank, my lord.
So that's why it has written. The Indian Bank address is not there now. You have to send in the because the Indian Bank has been merged with the Allahabad Bank. Now all the Allahabad is Indian Bank.
Allahabad Bank has merged.
Where is the notice written?
Here is the thing that has.
What is the endorsement?
On the other side, my lord.
Left without
instructions.
Bank left.
Yes, my lord. The bank has the branch of the bank is non-existent there.
Non-existent.
Non-existent. And I tried to locate from nearby branches. They said your loan account is not available here. That is true because last 15 years I don't have any loan. They are just harassing me during last 25 years.
What is your prayer here?
I have prayer here is that close my account, issue a
Setting aside and declaring the suit OA number dismiss. OA number is before the DRT.
Yes, my lord.
So how the DRT matter will be taken here?
Because DRT is not taking it.
Why?
Because I don't know. Because learned DR80 gave a specific instruction in August 2023 that complete the case within 3 months.
It's a surfacey matter.
No surface matter. OA.
So how the DRT come? OA will connected with the surface.
Surface is already demand is barred by limitation, my lord. They cannot enforce surface.
The bank has initiated. So how the OA? OA is the surface. Bank has initiated a surface matter. Have you received the section 13 notice?
No. That was given and that has been quashed by this Honorable High Court because the demand was barred by limitation. So they cannot ask me under SurfaceE Act.
No,
they have just under Section 19 of RDDB and FI Act, they have filed a recovery suit, and that recovery suit is going on for 25 years without any loan. That is the most tragic thing, my lord. And now I cannot find them. Where am I supposed to serve? Because they don't have any loan document of my loan. They have exceeded that. They have said that. And they have said that they employed TCS also to find out my loan account, and in vain. They could not find my account.
So there is an order on 15th November. There is a direction by this court directing the DRT and DRAT to conclude your proceeding within a period of reasonable period. What has happened to that?
Nothing. DRT is giving specially fixed at 230.
When?
Regular, whenever it comes, specially fixed at 230 under DR80.
But correct, sir. But this
But that was not taken.
This court cannot take this matter. This court is not having determination. You have to go to the other court. This is
What
not
to do
under-
now?
Yes.
What to do now?
I am releasing it. You go to the other court, which matter where the surface is having.
But this is not a surfacey matter, my lord. This is not a surfacey matter. This is under section 19 of RDD BNFI Act, a regular recovery suit.
Where is the notice? Where is the notice issued under DRT Act?
Oh, that original notice that I haven't annexed here.
So
that I haven't annexed. If your lordship give me time, 5-7 days, I will annex it. Everything. That's an original application. That is not a surfacey.
Where is the original application? What is the original application? You have a copy of the original application?
I haven't brought it.
So, unless and until the court will not go through, how it can be?
Give me a time of, my lord, 5-7 days. I will bring all the old documents. They have actually waived off my loan 15 years back, and they have kept everything surreptitious.
What you are telling, sir? Kindly come to the page 44 and 45. Notice issued under section 13(2) of the Surface Act.
Yeah. After that, your lordship kindly see that Honorable High Court, Honorable Mr. Justice Washak has quashed it.
What caused it?
Quashed the surfacey action because the demand is barred by limitation. They tried. They tried 4 times, not once. They tried 4 times. But the thing is that they don't have money. My loan account.
Okay, this order was passed in 17. Thereafter, what has happened?
Thereafter, just going on and on and on.
What?
That case?
No.
Just coming in the list. Every day I am going there.
How it is coming? Because the court has already set aside the issue raised, therefore, the answer holding that the initiation of the proceeding by the bank is barred by law under of the limitation, and all the proceeding taken by the bank consequent upon the person 13(2) is quashed. So thereafter?
Thereafter, just section 19 is going on. Section 19 case is going on and on and on. No, none of the days it is taken up. Every day at 4:15 or 4:30, I am saying, okay, next date. This has been happening over years. Specially fixed at 2:30, but it never comes at 2:30. At 4:15, 4:30, I have been called on. Okay, specially fixed, next date, this. And in 2023 August, the Honorable DR80 specifically said that finish it within 3 months without enough adjournment. And they have given already from that date, it is already 4 years.
Okay, you bring the away copy.
Okay.
The counsel for the petitioner is appearing in person and submit that he will place the record of the original application filed by the bank against the petitioner on the next date fix. According cases adjourned, let the matter appear on.
I will need very short time, my lord. 4-5 days, 6 days enough.
26 February.
My lord, 27th.
27th February. Next.
Grateful.
We have for the plaintiff. Concluded the arguments. We have concluded arguments. They are supposed to be.
Blood on last occasion. Blood, it was your lordship's pleasure that parties should try for a settlement. Blood, accordingly, blood, we arranged for a meeting of the parties. But unfortunately, it could not be settled because of the arrogant attitude of the defendant number 2. I'm very sorry to say I was personally present. He was not listening to us, not interested to settle the matter at all. Lordship, may kindly remember that this matter relates to infringement of our copyright in 2 particular books. And according to us, my lord, the period specified in the agreement of 2020 has expired in August 2023. Therefore, they do not have any right to publish the book, but in spite thereof, they are still now publishing the book. Okay? Yes. Yes.
Yes, then. So what do you want?
Lordship, may kindly fix up some other day, Lord, will distinguish their judgments and.
Today's fix. Not ready.
Yes, Mr.
You are
Ghosh
for
was
the
addressing
petition.
your Lordship, Lord.
You are for the plaintiff.
Yes, Mr. Ghosh was addressing Lord. His on.
Learned counsel for the plaintiff press for time according cases adjourned. Let the matter appear on 10th March. Next. Then 13th March.
13th of March. Wait.
Next.
Lord, at 3 p.m. Lord. At 3 p.m.
No. Normal is it will come. Yes, next.
This is my application, my lord, for
For
summary judgment in a suit for eviction against a trespasser. According to us, they are a trespasser, my lord. We had concluded our arguments.
Yes.
It was they to conclude their arguments. Passover, my lord, will not come back to your lordship. That luxury we have lost. May I beseech your lordship, my lord, to kindly fix the date and time.
Date, then we'll go up.
No, let it whenever, my lord. Whenever. And here, Miller, I'm sure Mr. Kaur, if he knows that it's going to be taken up on a particular day, and I'm sure he is going to come prepared, because he had he had almost concluded his argument. He was supposed to, Miller, argue maybe on just a last few points. Whenever it is, Miller, convenient for your lordship.
Learned counsel for the defendant press for time according cases adjourned. Let the matter give the date. 10th April at 3 p.m.
Yes, we'll definitely come to that. And we'll also will try to conclude the arguments in reply, whatever short reply.
Come on 10th April. We'll
yes. Yes, pleadings complete. Arguments, even arguments is also almost complete.
Next. Yeah, Mr. Urgent bolchi kichu hai.
No, just a moment. Is it lots of pleasure to keep it at 2 o'clock?
3
p.m. Okay.
Yes.
6, my lord. I'm for the applicant defendant number 2. But there has been a bereavement in the family of the arguing counsel of the my lord applicant. My lord. He has requested me to pray before my lord to the defendant number 2 applicant. Defendant number 2 applicant. Kindly fix it any date, my lord, next month, my lord.
As per the prayer made by the counsel for the defendant, case is adjourned. Let the matter appear on 18th March.
Grateful.
Next.
Well, we have already served the notes of argument, my lord, and the compilation of judgment, my lord. Lordship can, our submission was more or less over, my lord. It's only in their GA they would like to make some submission, I think. Copy আছে মানে ওদের নোটস নোটস তো দেয়নি কপি ও আচ্ছা রিপ্লাই
Yes.
This is our reply, which we were directed to file. This is the same submission I perhaps could not require to be.
Thankfully.
For convenience, but I do not want to keep engaged with all this because we have made
elaborate submissions.
Elaborately, both counsels. But these are supplementary written notes of arguments which we have prepared. But this is distinguishing the judgments, 13 judgments that they have given on the earlier date. But if I read one by one, it will consume a lot of time. I have mentioned what is not applicable.
I will go through.
And how, Malad, if this is causing any inconvenience to your lordship, Malad, to properly appreciate, Malad, kindly keeps it for hearing at any time that your lordship would require.
If your lordship feels any clarification is necessary, your lordship can keep it any day as to be mentioned. He can
Yes.
make our submission.
But in very short, we have distinguished it.
I will go through. If
And
necessary, I
if
will.
lordship would kindly allow me 1 minute time.
Yes.
Malad, what is happening here is an attempt where Malad, the Supreme Court's order that has been passed and the division bench order of the High Court, Malad, notwithstanding that, they are asking for disbursal of all amounts.
Disbursal of?
Disbursal of all amounts going to the accounts by virtue of using a power of attorney which has been cancelled.
That is the only crux.
Yes, that is the subject matter which is the primary subject matter in this suit.
If the cancellation is declared as a bad,
yes,
then the original will be remain. Yes. If it is declared as a correct,
then whether that can be done at the stage of injunction, that is tantamounting to granting of the final
relief. That is
I have made a prayer in prayer D, which your lordship will file just to work out the arrangement.
Mr. Sin doesn't allow me to speak at any time. It has happened. But
I'm embarrassed.
No, before this court, all the advocates will get the opportunity to argue.
Absolutely. But whenever I try to open, Manad, what is the case? But he gets very annoyed. He doesn't want me to place the case. But this is all that I wanted to say. I'm so very grateful to you all.
Thank you.
Obliged.
Affidavit in reply filed by the plaintiff.
No, respondent in GF4.
Respondent in GF4.
Defendant.
Defendant in GF4, be kept in the record. Both the parties have filed their written notes of argument and let the same be kept in the record.
It should be defendant petitioner in GF4.
Defendant petitioner, reply by the defendant petitioner GF4, be kept in the record. Parties have also filed their notes of argument. Let the same be also be kept in the record. Hearing concluded, CAV.
We have filed a compilation of judgments together with the notes.
Okay. But our supplementary notes of arguments may kindly be recorded. Great.
Thank you.
I am appearing on behalf of the defendant.
Yes.
Or I am for the plaintiff, Malad.
The defendant will start argument, Malad. This is a suit hearing. Yes, final argument in the suit, Malad. Signed, whatever.
Withdraw has conveniently passed the bucket on to me. And
No, I told Mr. Banerjee that I have to get ready in the matter. If Mr. Banerjee is not start, let me tell it to me. I'll get ready. But
nowadays, Mr. Mitra is not coming here because
no, my lord, it's not that.
Yes.
But we'll fix this matter. If I get this opportunity of 2 days, I will finish my final arguments of a suit.
You are for the?
I am for the defendant number 2.
You are for the defendant number 2. 1.
I will start my arguments. I am requesting your lordship to give me 2 days, within which I will be concluding my arguments, and then the plaintiff or rest of the defendant will start with that. Since this is a suit, I require some continuity, and I will finish my arguments.
Then the defendant number 1.
I am the defendant number 1 because I am practically I am a partisan.
Allegations are mainly against.
And my lord, the transaction I have already purchased. I have everything I have set of the position, and thereafter they say that we have revoked the power. But now after my lord, all this.
Okay. Record. The
bank loan.
Counsel for the let the matter appear on April दिन 2 डेट दो 4 डेट दो 24 25 24 27 29 4th May for argument.
Well, 4 dates for all of us.
Yeah. Continue.
Yes, continue it, my lord. We will get ready.
Not a half marathon, it's a full marathon.
Full marathon. I understand. for both of us, full marathon.
In the marathon, may I just seek for one change?
Our Kyola.
24th minute. Barring 24th, I am sorry.
April.
Apologize.
You can't have that long a problem.
Yes, next.
Obliged, my lord, obliged.
Highly obliged.
Lord, this is the application which we had filed under Order 7, Rule 11. Mr. Somrasen was leading me in this matter. And Lord,
Which matter?
This matter, Lord,
Panava
Monet
City?
Securities. Yes, Monet Securities. This is not this litigation. This the one which Mr. Thakkar was arguing. The other matter.
Not that.
Not that one.
This is another one.
This is the other one.
Who is for the plaintiff?
Where Mr. Abhijit Mitra was there. But given the situation, Millard, I understand that Mr. Mitra may not be. His mother passed away day before yesterday.
Yeah.
But we'll kindly let it remain in the list, Your Lordship.
No, I'm fixing next week.
My Lord will fix it.
Yeah.
We'll notify the other side. Millard.
Let, item
Kindly
number
give the
10.
direction.
Let the matter appear on 5th of March 2020.
Leave the-
Next. अच्छा WPO ले लेता खत्म हो जाता. Item number 11, 12. Who is appearing? Order recording the younger son of Priyadatta Development name. None appears on behalf of either of the parties. No accommodation is prayed for. Let the matter appear in the combined monthly list of April 2026.
My lord, I am Milap Choraria. Item number 13.
Yes, my lord.
Yes.
Number 2.
Okay.
My lord, I am Milap Choraria. My lord,
Yes.
I am Milap Choraria, my lord.
Yes. What has happened to the Supreme Court?
There is a judicial subordination because on 19th September, matter was listed before Chamber Court, and Chamber Court allowed me to cure the defects within 8 weeks. Then I have cured the defects. Thereafter, on
Yes.
On 11th November, matter was disposed of illegally. Then I made a complaint before the Secretary General of Supreme Court. Then it was recalled, and thereafter Supreme Court website shown that it will be listed on at February, at December. But matter was not listed. I have made several complaints, but till date not listed matter. So time being, this is my application that matters would be put and out of the cause list for time being. I will mention.
My lord, my submission is just.
You are appearing for?
Defendant number 2, Google.
Yes.
My lord, plaintiff is not there.
Hmm.
I humbly submit that let us just have this suit dismissed under Order 9 ruling and end this luxury litigation, because when my client from US, they are saying that, I mean, there is no end to the
The defendant number 1 is appearing in person through virtual mode.
My submission should be recorded in the order.
Number 2 submit that for the last several days the plaintiff is not appearing in the matter and press for dismissal of the suit. This court also finds from the record that the plaintiff, whenever the matter is called, none appears on plaintiff for the last several days. Accordingly, CS number 250 of 2011 is dismissed for default.
My lord, a cost should be imposed upon the plaintiff.
Interlocutory application is also dismissed. Next.
Dismiss कर दियो सूट तो चलो
This suit, Milord, 2 words and it will come back to your lordship.
Yes.
Circular transaction.
Yes.
Milord, Mr. Thakkar was leading me and Mr. Joyanto Mitra is our leader, Milord, in the matter. Milord, Mr. Dutt has perhaps concluded in reply.
We were in reply. We had concluded our reply. But we had to rely on certain authorities and judgments, Milord, while we were giving the reply. Those, Milord, have to be dealt.
So, Milord, there were 3 judgments, Milord, which Mr. Dutt had relied upon in reply to suggest that even if it is a situation where your lordship will not be pleased to pass an order in the application for judgment upon admission, security can be ordered by him.
Yes.
And those were the 3 judgments on that line, Milord. Milord, Mr. Mitro is my leader, Milord. If your lordship can keep it any convenient day, Milord, Mr. Mitro will reply and Milord deal with the judgments. That's my instructions, Milord. I've spoken
My
to
lord
Mr.
can keep it,
Banerjee
Milord,
any day, Milord.
in
As
first
per
week
the
of
prayer-
March or
As
whichever.
per the prayer made by the counsel for the defendant.
Depend.
Counsel for the defendant, the case is adjourned. Let the matter appear on
This is judgment upon admission application.
12th March.
12th.
Deep Lord.
Next. None appears on behalf of either of the parties. No accommodation is sought for. Let the matter appear in the combined monthly list of April 2026. Next. Same order.
Seventeen, my lord, I'm led by Mr. Arif Ali, who is on the virtual mode. I'm for the plaintiff. It's my
Yes.
This is a simple substitution application, my lord. One of the defendant passed away, and we have filed our application for substitution.
GA4. 4.
Yes. What is the application? What is the prayer?
Ashok, this is my prayer for substitution of the defendant number 3, Lily Morant, who had passed away.
You are for the plaintiff.
I am for the plaintiff.
Defendant number 3.
Defendant number 3, Lily Morant.
More defendant number 3 be stuck of expunge and to substitute the legal. When he died?
She passed away on 29 July 2023, and Lordship I have disclosed the orders by which the defendants were directed to provide the date of death and the certificate of death, etc. Because she passed away not in India, she passed away in UK. And ultimately, Lordship, once we received the death certificate, we have filed the application.
When you received?
If we have received 14 November 2024.
14 November 2024.
Followed by 26 November 24, which is at page 16.
The death certificate was given, which is at page 14, and page 16, the particulars of the legal heirs were supplied to us.
That is also after 90 days.
Lordship.
Yes. But within that 150 days. Within the
within the additional 60 days.
The plaintiff has filed the present application being GA4 of 2025, praying for recording the death of the defendant number 1 and substitution of the legal heirs of the defendant number 1. Full stop. Counsel for the counsel for the plaintiff submit that by an order dated 6th of November 2024, this court directed the defendant to supply the copy of the death certificate of the defendant number 1 as well as the details of the legal heirs of the defendant number 1 to the plaintiff. And in terms of the order passed by this court on 26 November 2024, the learned advocate appearing for the defendant number 1 has communicated forwarded the copy of the death certificate as well as the legal heirs of the defendant number 1. Full stop. From the death certificate, it reveals that the defendant number 1 died on
29 July 2023.
29 July
2023.
2023, leaving behind
only one legal heir.
Where is the legal heirs?
Well, kindly comes to pay the proposed amendment at page 38.
Leaving behind only one legal heir?
Yes, my lord.
Only one legal heir, being this, namely Andrew Dayal Morant, being the son of the defendant number 1. Full stop. Heard the land counsel for the plaintiff, produce the materials on record. You are appearing, Mr. Dasgupta?
No, Lordship, I have a Lordship, intervening application, that is GA2. No problem, Lordship, this substitution application.
Heard the land counsel for the petitioner plaintiff, produce the materials on record. This court find that the defendant number 1 has died, leaving behind his sole legal heirs, namely Andrew Dayal Morant. Accordingly, the name of the department is directed to delete the name of the defendant number 3. Defendant number 3? 3. Subject 3 hai na? 1 hai. 3 hai.
Defendant number 3, Malad.
3 had died. 3 karna. Defendant number 3 and to add the legal heirs of the defendant number 3 as 3A in the cost title.
There is one more minor correction, my lord. Kindly comes to page 37. The pin code of the plaintiff is mistyped, my lord. Wrongly typed. I have corrected
Plaintiff
that.
has also submitted that, and that the pin code in the cost title of the plaintiff, the pin code of the plaintiff, address of the plaintiff is wrongly recorded as 70091 instead of 7000106. According, plaintiff is given liberty to correct the pin code of the
I'm
plaintiff
praying
in the
for
cost
prayers,
title.
my lord. A to E of the master summons.
Consider the submission made by the counsel for the plaintiff. Prayer
A to E.
A to E of the master summon is allowed. Master summon is allowed. GA4 of 2025 disposed of. Okay.
I'm grateful, Malad.
Disposed of. I think they don't have any objection in connection with IAGA2. IAGA2, your lordship, is an application for addition of party. The reason is, your lordship, during the pendency of this particular suit, I have, your lordship, purchased the entire property in my favor. On the last occasion, I think they have given a statement that they don't have any objection if my application is allowed. GA2. Mr. Ali.
Lordship, the intervener may be Lordship, we may be given liberty to add the intervener, Malad, without prejudice to our rights, Malad. We have no problem. Because, Malad, since he's a purchaser, Malad, he has to be made a party now.
30. I have pleaded in paragraph 30. Page 9. This is my suit, your lordship, which is CS50. During the pendency of CS50 of 2011, a settlement was reached between the parties and terms whereof are recorded in the memorandum of settlement. The Honorable Court has approved the settlement and in terms thereof has passed a consent decree dated 23rd August 2022 directing the memorandum of settlement be recorded and not to be carried out and the same is ordered and declared. Page 189. Is the decree passed in my favor?
Yes.
So today, Your Lordship, I have stepped into the shoes of the original owner.
So you are this is the suit property.
Yes, Your Lordship, the identical property. Entire property has been purchased by me through a court order.
The applicants have filed, applicant or applicants?
Applicant.
Applicant.
Applicant. Applicants? Who are they?
Applicant, Your Lordship, this is Rajeshri.
Where is that? Rajeshri. These are J2, no? Where is the applicant?
Rajeshri Developers Private Limited. RAJSHI. Rajeshri Developers Private Limited.
Sole.
Applicant.
Where it is mentioned?
Lordship, kindly take Your Lordship the affidavit in support of Master Summons.
Suja Biswas.
Paragraph 1. I am one of the directors of Rajeshri Developers Private Limited.
The applicant Rajeshri Developers Private Limited has filed the present application being GA2 of 2023, praying for addition of party, addition of defendant in CS number 297 of 2022. Counsel for the applicant submit that the applicant had filed a separate suit being CS 50 of 2011, and in the said suit, as per the settlement entered between the applicant and the defendant in the said suit, this suit was decreed. And the decreed, and in terms of the said decree, the plaintiff has purchased. You have purchased the property.
Yes, Your Lordship. I purchased
The applicants have purchased
Lordship, the applicant's nominee, I am the applicant here, but the plaintiff's nominee is the applicant.
Plaintiff's nominee means?
Plaintiff, Your Lordship, is the Jan Infrastructure Limited.
Plaintiff's nominee of TS.
No, I am the plaintiff.
No.
50.
CS 50.
50, that's why.
And I am the nominee of plaintiff, Your Lordship, Rajeshri.
My learned,
the property has been transferred.
my learned file did not file CS 50. Jan Infra Projects Limited filed CS 50.
Okay.
And I am the nominee of Jan.
Okay. Key bolo upar.
Now our contention is there's a completely collusive, Lordship, that non-est in the eyes of law.
Application GA2 of 2023, praying for addition of his name as defendant, as added defendant in the suit on the ground that in terms of the decree passed by this court in CS 50 of 2011, he is the nominee.
I am the nominee. Applicant is the nominee.
Who has purchased that property?
Jan Infrastructure is the plaintiff, but the sale deed has been executed in favor of Lordship the applicant.
Jane Infrastructure. You're not mentioned here. Where is
page 192 if Your Lordship kindly see. 192. I think volume number 2, Your Lordship. First name, Your Lordship, Jan Infra Projects Limited is the plaintiff.
Jane Infra Projects Private Limited have purchased the suit property, and the applicant is the nominee of the Jane Infra Project Limited. Accordingly, plaintiff and accordingly, applicants have got right at an interest in the property and intend to add in the interest in the property, and accordingly intend to add to be added as a defendant number.
Defendant
respondent 16. Defendant number 16 in the present case. Learned counsel appearing for the plaintiff submit that the applicant.
The settlement which was arrived at is completely non-est in law, and we are taking steps to.
For the defendant plaintiff submit that the plaintiff has not aware with regard to the settlement arrived between the parties in CS 50 of 2011, and the plaintiff will take appropriate steps, and without appropriate steps with regard to the decree passed by this court in CS 50 of 2011, but the applicant may be added as a defendant number 16 without prejudice to the rights and contention of the plaintiff. Consider this made by the counsel for the parties. The Department is directed. Where is the prayer?
Prayer A.
Master summon.
The prayer A of the master summons, Your Lordship.
Consider the summon named by the council for the.
Applicant Rajashri Developers be implemented as a party defendant.
Prayer A and prayer A. Prayer is allowed. Full stop. The department is directed to add the applicant, namely Rajashri Developers Private Limited, as defendant number 16 in the present suit. Full stop. The plaintiff is directed to de-verify and reaffirm the affidavit within a period of 2 weeks after the addition of the defendant number 1, and to serve the copy of the plaint to the plaintiff within a week thereafter. GA4 so disposed of.
I'm grateful.
Next.
I appear for the plaintiff in item number 18. But 18 and 19 are connected matters.
18 and
19. Two wills of the same testator. In 18, my lord, I am for the propounder. My lord, item number 19, I am for the caveator. Item number 19, your lordship will remember, my lord, it's that matter where lordship passed an order for revocation. I am for the wife and the caretaker sort. My lord, in this item number 19, we have been cited and we have filed our caveat and the affidavit in support of caveat. So, my lord, your lordship can direct in item number 19 to the department to give a testamentary suit number. Item number 18, that is my application for grant of probate, my lord, your lordship will kindly see your lordship's order dated, my lord, 18th March 2025. 18th March 2025, my lord. May I place the order before your lordship once? Such and such advocate is appearing for the petitioner in PLA number 323 of 2022 and caveator in PLA number 320 of 2018. Such and such learned senior advocate is appearing for the petitioner in 320 of 18 and caveator in 323 of 2022. The counsel for the petitioner in 2022 submits that the caveator has lodged the caveat but has not filed the affidavits in support of caveat within the period as prescribed under the law. Counsel for the petitioner in 323 of 2022 submits that the caveator has filed affidavit in support of caveat. Counsel for the petitioner in such as on instruction submits that if 1 week time is granted, he will take appropriate steps for withdrawal of the appeal preferred by the petitioner in PLA number 320 of 2018. This appeal has been actually, by the other side, has been withdrawn. They have withdrawn this. Counsel for the caveator in PLA number 323 of 2022 prays for a week's time for filing of affidavit in support of caveat. For the interest of justice, a matter of last chance, time for file of affidavit is extended for the period of 1 week from date. It is made clear that if within a week the caveator fails to file an affidavit in support of caveat, he will be proceeded without affidavit in support of caveat. So this is, my lord, in item number, my matter, which is in item number 18. They did not file a
323.
323 is item number 18. They did not file. But, my lord, yes, they have made an application before your lordship today for extension of time to file caveat. My lord, I am not standing in the way because this is going to unnecessarily, they're going to go up to appeal. It is going to delay my probate application. The lordship will allow them to file a caveat within a specified time.
Where is that application?
I think it's in the list.
GA1.
30th July, you have
GA1. GA1 is
the.
Where is the master summon? Allow the applicant formally to file caveat and affidavit in support of caveat.
Yeah, this is made by them. Please, my lord, I do not want to really go into the controversy because it is unnecessarily. They have a right, let them file their affidavit in support of caveat within a specified time. Since your lordship has already given them last chance, they did not file. Your lordship will put them in terms if your lordship so desires.
Who is there?
My lord, Mr. Dotto had appeared in the matter earlier. But my lord, Mr. I think
if today I pass an order, then they will not find what
I'm telling them.
My lord, I had my lord put in that as item 18 and 19, but I don't have any instructions to appear. Just my lord to clarify. So I am not there in 18, 19.
My lord, let them file their affidavit in support of caveat.
And my lord, my matter, since I have already filed my affidavit in support of caveat, a testamentary number be given by the department, because that's the course, my lord.
Can left, Mr. Datta. Left. The one Mr. Ram Singh has filed the present application being GA1 of 2025 in PLA 323 of 2022, praying for filing caveat and affidavit in support of caveat in respect of PLA 323 of 2020. Learned Counsel for the, you are for the executor.
I am for the executor in 2022 matter. 323 of 2022. I am for the executor.
Counsel for the executor submit that by an order dated 18th March
2025.
18th March 2025, this court has granted the applicant Ram Singh to file the affidavit of caveat within a week. To file affidavit in support of caveat within a week. But in spite of the direction, in spite of the time granted by this court, the applicant has not, the caveator has not filed the caveat or affidavit in support of caveat. Full stop. He submitted only because the caveator is not filing the caveat and affidavit in support of caveat, the matter is delaying.
Yes.
Delaying. Can record your submission to allow.
Record it, my lord. It is in fact delaying.
The executor submit that as a matter of last chance, he may be granted time to file affidavit or caveat as well as affidavit in support of caveat. Consider the submission made by the counsel for the executor, the caveator, Mr. Ramji Singh is granted time to granted time to file caveat as well as affidavit in support of caveat within 2 weeks from date. 2 weeks from date after serving the copy to the learned counsel for the executor. GA number 1 of census disposal.
Kindly make this peremptory because no chance.
It is made clear that within the set period, if the caveator failed to file the affidavit, a caveat as well as affidavit in support of caveat, no further chance shall be granted, and the matter with the PLA 223 of 2023 will be taken up for hearing as non-contentious case. The counsel for now regarding 19. Counsel for the executor. You are an executor?
No, my lord. In 19, I am for the caveat.
Counsel for the caveator in PLA 320 of 2018 submit that the caveator has already filed the caveat as well as affidavit in support of caveat. In view of the above, the department is directed to assign the testamentary suit number and to place before this court on the next date fixed. Let both the matter be appeared before this court on 18th March.
Good. I'm grateful, man.
Next.
Lordship, in item number 20, I am for the petitioner. My senior, Mr. Megzid Mukherjee, Mr. Megzid Mukherjee is not able to.
Who?
Mr. Megzid Mukherjee. So I'm paying for not today, Your Lordship.
Not today. Next.
My lord, I appear for the plaintiff respondent opposing the application for rejection of plaintiff.
Lordship.
Going on.
I'm for the defendant. And it has been marked as part heard. And the last hearing was conducted on January 8, 2025.
I hope my learned friend will conclude today, my lord, since it's continuing for an year now.
Will conclude, but since the last hearing was 1 year, I'll take some time to recall and continue. Yes, recapitulate the submissions. I'll give it some time.
Yes.
Lordship kindly takes up the plaint. This is an application for rejection of plaint. This plaint has been instituted on the basis of an assumption that a deed of assent has been granted.
With a
Deed of assent has been granted. There was a probate, there was a will. The will had obtained probate. The plaintiffs had obtained probate of the will. And as per the will, the plaintiffs are the beneficiary of the property. Now, they have filed a suit. They have filed a suit saying that now we are the owners of the property and please leave from the property. Now, my point is that today there has to be a cause of action. They have not executed a deed of assent or has pleaded anything to that effect as to how the plaintiffs had attained the ownership or their cause of action has arisen. I have challenged the plaintiff in respect of that. Ashok kindly comes to section 213 of the Indian Succession Act.
Of the
Indian Succession Act. আর বই নেই না এখানে আছে তো আমার খোলা নেই বই মনে হয় পাচ্ছে না I'll give mine. আমারটা
section
213.
230.
Yes.
Yes.
213.
Yes.
No right as executor of legatee can be established in any court of justice unless a court of competent jurisdiction has granted probate of the will under which the right is claimed or has granted letter of administration with the will or with a copy of an authenticated copy of the will annexed. Now it is established and admitted that they have not become the owners of the property before the probate was granted. They had no right. So the right that they could have obtained is only after the
You are the plaintiff here.
I am the defendant here.
You are defendant.
Yes, these are my application for rejection of
Okay.
They could have only attained such right. Number one, after the probate is granted. Number two, after an assent has been granted to himself. That is to say that in the will, the plaintiff was the executor. The plaintiff sitting in the chair of an executor must have granted the assent to the plaintiff again sitting in the chair of the legatee. That assent has not been granted and hence my application has arisen. Ashok kindly takes up section 332.
Three
332.
Yes.
Assent necessary to complete legatee's title. The assent of the executor or administrator is necessary to complete the legatee's title to his legacy. Now, may I ask this question to myself that
Assent necessary to complete legatee title.
legatee's title.
Yeah.
Hence, if there is no assent,
The assent
then
of the executor of the administration necessary to complete legatee's title.
hence, in a circumstances where there is no assent, there cannot be any title. Now 335.
Yes.
Assent of executor to his own legacy. This is my case.
Yes.
The plaintiff must have given the assent to his own legacy. When the executor or the administrator is a legatee, his assent to his own legacy is necessary to complete his title to it, in the same way as it is required when the bequest is to another person. And his assent may, in like manner, be expressed or implied. Assent shall be implied if in his manner of administering the property, he does any act which is referable to his character of legatee and is not referable to his character of executor or administrator. Now, here the act must be, the plaintiff ought to have conducted an act which shows that the plaintiff has granted assent to his own legatee. In a respect of where a money is lying in the bank account, if the plaintiff, being the executor, has utilized the money for his own needs, then an assent will be conducted. In this case, if the plaintiff had issued a letter to the defendants saying that now I am the owner of the property, kindly, I need to recover the possession, move away. That would be an assent. That would be an act that the plaintiff would conduct against the defendant in respect of section 335. But today, the plaintiff has failed to indicate any act which could have, for which the cause of action of this suit could have accrued.
What would be the effect?
The effect would be rejection of plaint. The effect.
Correct. If rejection, what would be effect of the probate granted by the court?
Lordship, I fail to understand.
Probate granted.
The probate
granted.
Yes.
Now they intend to become the owner. Correct. So as per your case, 332, 335 is to be complied with.
Yes.
Communication to the defendant.
Right.
Action. Without the action, he cannot claim the ownership over the property. This is your case.
Yes, yes.
Correct.
Now, Lordship
So
is asking.
that's why, if suppose the plaintiff has not given a letter,
Right.
so what would be effect of
Lordship,
the
that
probate?
led to the revocation of the probate. Lordship kindly comes to section 317 of the Indian Succession Act.
317.
17. Yes. For that, we have filed an application, and I should not indicate it here, but they have also filed an application there to file their inventory and accounts.
That is different.
That is different.
That is different.
We have filed the revocation application on the basis of two-folded submissions. One being the inventory and accounts has not been completed.
Not correct. Okay, that is different.
That would lead to the revocation of probate. And in this case, if they have not carried out the inventory and accounts, they have also not assented to the other beneficiaries. Not only them, they have failed to assent to the other beneficiaries as well, including me. I am also some of the beneficiaries in the will. They have not granted me that legacy as well. Hence, that would, if the honorable court permits, that would lead them to revocation of the probate. And in this case, if they have not granted an assent, then they have not accrued the title. And if they have not accrued the title, then they do not have any cause of action to file the instant suit. Hence, Order 7, Rule 11 comes in, and they're exposed to subclause C, no cause of action. Lordship kindly takes up the plaint. Plaint. Watch.
Yes.
My application is page 13 of my application. The plaint is annexed. Thank you.
Yes. GA1.
GA1, GA2. GA1 is extension of my time to file the written statement. Lordship, the first page, paragraph 3, the defendant number 1, I will indicate how they have pleaded their cause of action.
Paragraph 3 of?
The paragraph 3 of the plaint.
Yes.
The defendant number 1 is the younger son of Dulal Chandra Bhor and Urmila Bhor. The defendant number 2 is the wife of the defendant number 1. The defendant number 2 and 3 and 4 are the son and daughter respectively of the defendant numbers 1 and 2. Now they start to plead. Dulal Chandra Bhor died on June 27, 2000, leaving behind his last will and testament dated December 1, 1999. Inter alia, bequeathing the suit property to the plaintiff. Both the plaintiff and the defendant number 1 were appointed joint executors of the said will. Thereafter, they have pleaded that the defendant number 1 has refused and neglected to discharge the obligations, which is not relevant perhaps in this proceeding. Then they have pleaded that by judgment and decree dated August 19, 2015, passed in title suit number 3 of 2003, probate of the said will was granted by this honorable court by a judgment and decree dated August 19, 2015, as corrected by so and so order. An appeal was preferred thereafter. Now, paragraph 8. The plaintiff, in his capacity as the executor, has expressly and or impliedly assented to his own legacy to complete the title of the plaintiff to the suit property. By reason thereof, the plaintiff has become the owner of the suit property with effect from June 27, 2000. Lordship now kindly comes back to paragraph 4. Dulal Chandra Bhor died on June 27, 2000. They could not have expressly or impliedly assented before the probate has been granted. Now here they have failed to state whether there was any assent after 2015, September 2015, when the probate was granted. Now,
what would be effect once the probate was granted? You are the party to all along. You are the party, and you challenge that probate.
Yes.
What would be effect?
Lordship, thereafter, when a probate is granted of an will, the condition or the assent that is mandatory in nature. I am not disputing that the probate has been granted. 332. Assent necessary to complete legatee's title.
Correct.
The assent of the executor or administrator, in my respect, executor, is necessary to complete the legacy's title to his legacy. The executor today, in order to complete his title, ought to have assented. I say that they have failed to assent. Hence, their title is not complete. Today, if their title is not complete, then I ask this question to myself, how could they have filed the eviction suit?
So how you telling that how the assent is to be taken?
Now,
Assent
here
necessary
comes,
to complete. How the assent is to be taken?
I'll indicate that. Here comes section 335.
Correct.
Assent of executor to his own legacy.
Correct.
Exact case. When the executor or the administrator
Is a legatee.
Here in this, his assent to his own legacy is necessary to complete his title to it.
Correct.
In the same way as it is required when the bequest is to another person, and his assent may in like manner be expressed or implied.
Correct.
Now, my submission is that that assent ought to have been by way of an letter, that the executor is saying that to the plaintiff that I have given assent as an executor to the legatee, being again myself. Now, I say I do not permit you to reside in this property anymore. Kindly leave the property. Or even if they had pleaded that, even if I am not asking them to give that letter, even if they have pleaded, that would have sufficed. That wouldn't expose them to the application under rejection of plaint.
So it cannot be taken. It cannot be taken once father died.
Yes.
Father died, you had a will.
Yes.
Plaintiff had the will.
Right.
And plaintiff requested you to come.
Right.
You failed to come. Then files an application because you did not given the consent.
Yes.
You did not given the consent. The suit, the probate case initiated.
Yes.
You contested.
Yes.
Contested. So that is not in continuation.
That probate, what have been granted, that is a separate chapter today. After the probate has been granted.
So that's why I'm asking. So the assent means after the grant of probate.
After the grant of probate, the assent has to be.
Where is the condition? You satisfy that. So that's why my question is specific. After the death of the father, plaintiff made a request.
Yes.
Correct. And you not come forward, or you denied or objected, whatever it may be. Whatever it may be, then probate case started and all these things, division bench or single bench or division bench or till the appellate court, Supreme Court. So the application, the request which was made, you have denied. It is not a continuation. And if it is not a continuation, you are telling that assent is to be given after the probate under which provision, or where it is, what is the assent?
Number 1 point. I'll get back to that.
That is
perhaps
only,
not today, but I will get back.
That is only.
Yes.
If you satisfied, yeah, that is not a consent. After the grant of probate, again a consent has to be obtained by giving a letter or intimating that yes, probate is granted, come forward.
Right.
So where is that? That is the only question.
And if there was no assent after,
they have made out a case in paragraph 8. Impliedly.
Yes.
So impliedly means the application made by the plaintiff prior to the PLA.
Prior to the PLA.
So that's
That
why
is
impliedly. I don't know. I have, as per this, as far as my knowledge goes, as per this contention. So this impliedly means the letter which has been given by the plaintiff to you before initiation of the probate proceeding. So once that letter is given, and that is the continuation till the probate is granted, and you have contested that. You have contested that. So that is the only thing you have to prove. The assent means after the grant of probate, again the assent is required. That is
so
only.
today, the query or the thing that Lordship asked me is that whether if the assent has been granted,
taken.
If the assent has been taken
or informed,
whether the assent could have been granted before the probate. This is the short proposition.
My specific question is two questions. First is that before initiation, after the death of the father, the plaintiff requested you, see, there is a will, come forward.
Right.
For the settlement. As per the will, you are not come forward. So there was no consent. So he filed the probate case, you filed the caveat and all these things, it was continuing.
No, it went up to the Supreme Court and the plaintiff got the probate. And after the probate, so as per the case of the plaintiff, once the probate is granted, he got the title, so he came back for the suit. So he's telling that it is expressly implied because initially he has given the letter to you, you have not
Initially,
come forward.
They have not given the letter.
Before probate case.
Yes, they have not issued any letter. The date which they have stated here is the date of the death of my father.
That is correct.
Yes.
But after the death, the will was there.
Yes.
So how the will has come? Plaintiff requested.
Plaintiff requested.
Correct. So that is one thing. If that request is to be taken as a
Construed as an
continuation.
continuation.
Or if you are telling that no, after the grant of probate, again he has to inform the legatees. These are the two.
These are the two questions. Lordship, may I
Only two questions.
may I come back on these two issues?
Thank you.
Great.
The defendant has filed an application being GA2 of 2024 under Order 7 Rule 11.
Order 7 Rule.
Order 7 Rule 11 for rejection of plaint. The defendant has argued the matter at length, but due to paucity of time, the hearing could not be completed. According case is adjourned. Let the matter here.
Maybe request next week, my lord, because this has been pending for a while now.
Month list of March.
No, my lord, it's just a, my lord, it's, lordship has, my lord, summarized the point. It is now only, my lord, to address on that point, and I will assist your lordship on section 335, what it means.
Let the matter appear on 11th March. Come on 11th.
After. Very well.
Thank you.